Yes.
My lords, I appear for petitioner in this matter. Been an arrest warrant issued against the petitioner, my lords. It will be taken up at 2:30, my lords.
It should come in this. When did you file it?
Day before yesterday, my lords.
If the
22nd.
office objections are complete, it will come tomorrow.
No, recovery
Yes.
proceedings under 125 CRPC.
Huh?
Recovery proceedings under 125 CRPC is already filed. Section 125 CRPC is already filed. I filed this RPFC petition challenge the main order. Tomorrow.
No, if office objections are
Office
complete, then
objections
only
are
it will come.
complete.
Lordships kindly, my lords. This matter was listed on 15/9. Your lordship had issued notice, my lord, and to serve on the advocate and to, my lord, file a memo regarding service. I have filed it. My trial court matter is listed for arguments on Saturday, my lord. It was listed on Monday. It is adjourned to Saturday. Might be tomorrow.
Yes.
May I, your ladyship? Yesterday, the same matter, your ladyship. The birthday of the father and Dasara vacation.
The order passed.
The order was passed on 20th. I got the certified copies yesterday. I filed.
Office objections are complied
Are
with.
complied.
Then list, otherwise no. Yes.
Yes. Obliged.
Call the list.
Page wise adjournment. List number 1. Page number 2. Page number 3. 7 to 14.
Serial number 10, my lord. I am for the petitioner.
Yes.
I am not feeling well, my lord. 1 week time, my lord. Because due to some fever, my lord.
After vacation at the request of non-counsel petitioner.
Your serial number 5, my lord.
Page number 3. Page number
Your
4.
serial number 5.
Page number 15 to 18. Page number 5, 19 to 27.
My lord, serial number 19. My lord.
I'm for the petitioner, serial number 24. The matter is being settled, my lords, in the family court. They've referred it for mediation and they're coming in terms for the settlement. Lords, kindly listed after vacation.
My lord, serial number 19. Praise for a week's time, my lord.
Have you informed the other side?
Yes, my lord.
It is a request of counsel for the petitioner and it is submitted that they informed the other side. List this matter after vacation. Yes.
Page number 6. Cell number 28 to 31.
List this matter after vacation.
List number 2. Page number 1. Serial number 2. Page number 2. Serial number 3 to 7.
Who is the other
Serial number 13.
It's coming up for the first time. Somnath H. It is submitted that counsel appearing for the wife has already informed the same to the counsel appearing for the husband. List this matter after vacation. Date we can't give. Yes.
List number 2, my lord.
List number 2.
Serial number 13.
List
Please
number
call the list, please, please. Yes.
Serial number 5 in the second list. Lord, in this, Lord, I am appearing for the respondent. Lord, respondent wife also filed the Lord revision petition to enhance my Lord the maintenance. That is, my Lord, the husband filed the petition that is posted, my Lord. My petition, my Lord.
IA number 1 of 25 is filed to condone the delay of 41 days for the reasons stated. Condone. List along with, give the number, write on a paper and give.
Yes.
Yes.
List number 2, serial number 13, my lord. Opposite.
Page number 3. Serial number 8 to 13.
Yes.
13, serial number 13.
Yes.
Page. Opposite, I informed, my lord. After vacation.
Yes. You are for?
Petitioner. Appeal.
The request of non-counsel the petitioner. Let this matter after vacation is submitted. It already informed to the other side. Yes, next.
Page number 14. Page number 4. Serial number 14. List number 3. Page number 2. Page number 3. Serial number 9. Page number 4. 10 to 11. Page number 5. 12 to 13. Page number 6. Serial number 14. Page number 7.
We'll call for it. 14 that, yes, next.
Serial number 7. Page number 7. Serial number 15, 16.
Lord, serial number 16, my lord. Senior is not well. Kindly a week's time may be granted.
Have you informed the other side?
Yes,
At the request of learned counsel, the appellant claimant,
Yes. Appellant insurance company.
at the request of learned counsel, with the appellant, this is matter after vacation. It is submitted that they already informed. Yes.
Page number 8, serial number 17 to 21. Page number 9, 22 to 25.
Serial number 22, my lord.
Hmm.
Only a week's time available.
Why every matter you're asking for time?
No, my lord. Senior is not available. She's not well, my lord. So,
Last week also you said the same thing. Senior is not well.
no.
I remember the Gita Arts matters are adjourned on this ground. Why every week she's not feeling well?
No, not like that.
That's not right. And that too matters filed by the insurance company. You can't seek adjournment at all. But you have a stay, you're enjoying the stay. List this matter after vacation.
Page number 10, serial number 26 to 28.
Number 26, my lordship. Kindly have it done after vacation, my lordship. I have
20?
26, my lordship.
Why?
So senior is not well, my lordship.
At request, list this matter in the month of December.
Page number 11, serial number 29, 30. Page number 12, 31 to 34. Page number 13, serial number 35 to 38. Page number
36, my lord. 36, my lord.
Yes.
After vacation, it may be posted because recently I have to produce some decisions, my lord. Supreme Court decision. Recent decision has come.
This matter in the month of December. At the request of the unconscious claimant. Yes.
Page number 14, serial number 39 to 42. Page list number 4, referring to Lok Adalat matters.
A week's time a week's time for complying with office objections. In 2, 3 refer to Lok Adalat.
List number 1 for dismissal, serial number 1, Mohan BK.
Petitioner, my lord.
Kalika.
Yes, please argue.
My lord, sir, in the previous date of hearing, my lord, sir, they had claimed that they are paying certain amount to the petitioner and the children, my lords. They had filed a memo to that effect, my lord. This pertains to the school fee and other curricular activities per annum, my lord, which is roughly coming to around 35,000 per month, my lord. And his salary is around 2 lakhs per month, admittedly, my lord. He had also claimed that he is paying 25,000 rupees per month by depositing the amount in Bank of Baroda, which is not correct, my lord. If at all he is depositing the 25,000 rupees, my lord, I have no grievance, my lord. That matter can be closed with a direction to him that the 25,000 rupees, in addition to the 13,000
No. Let him complete.
No.
Yes, my lord.
According to you, you're paying 25,000 apart
Please,
from the educational expenses.
Please.
So we will say you continue to pay 25,000 on educational expenses, and we'll dispose of this.
But
petition.
not in addition to that 13,000. That should be included 13,000.
My lord, my petition is for...
One second. Let me. You.
Yes, sir. I'm sorry. Continue.
13,000 as directed by the family court.
The whole amount is 25,000.
Please. Then I have no grievance.
Along with the medical education.
Please. But
yes,
only my submission.
Yes, Mr. Mohan.
My lords, taking his 2 lakh per month income, my lords, 40,000 rupees for 3 persons.
No. 25,000 plus 35,000.
Yes, ma'am. No. 35,000 he claims that he is paying towards the education expenses, my lord. In addition to that, the court had granted 13,000 towards the interim maintenance, that is for food, clothing, and other things, my lords.
Please understand, the order is going to be he has to take care of the educational expenses, and apart from that, he will be paying 25,000 per month.
I understand, my lord. What I'm requesting your lordship is that let the 25,000 be in addition to 13 what the trial court had already granted interim maintenance, my lord. Because he is earning 2 lakhs for himself. In that, if at all he gives 60 or 70,000 rupees to his own family, my lords. Three children need to survive, my lords. 3 people.
Almost 40% salary we are giving as maintenance.
My lords,
Is your salary 2 lakhs?
No, it is 1 lakh.
no, my lords, it is admitted in the petition that as
That
per
is
the
after all
exchange
deductions
currency,
1
it is
lakh.
coming to
Yes,
Process 2.
yes.
What are you doing other 1 lakh?
My father and mother are residing in my native place. I have to take care of them also. See, your lordship may kindly see, entire educational expenses have been borne by the
Then what we
husband.
do is, we'll for 3 people, we'll make it 30 and education expenses.
Your lordship, last time what he made a submission that if 25,000 is ordered, he will withdraw. I conveyed to my client, and he said if that is so, he have no grievance. That is why I made a submission to your lordship that if
Yes, I'll record that.
25,000.
Yes, please come. Agree with the
my
order
lords,
passed.
may I submit just one thing, my lordship?
Yes.
He had said that he is already paying 25 in addition to the orders that has been passed by the court. My
No,
lord.
no, I'm sorry.
He didn't say so.
No, that is not my
Read the
submission.
order passed in. Criminal miscellaneous in on an what is the IA number?
IA number for
IA.
interim maintenance.
That I know. What is the number of the IA? That's what I'm asking.
IA1.
It doesn't say so.
It is not mentioned.
Wife has filed a criminal miscellaneous seeking maintenance. In that she has filed an IA seeking interim maintenance of an amount of rupees. How much you sought for?
My lords, sir. Sought for 50,000 rupees, my lords.
Your lordship will get it, page 27.
As interim maintenance.
1,50,000.
Family court by order impugned had granted
Paid.
3,000 to the wife and 5,000 each to the 2 children. Altogether, maintenance of an amount of rupees 13,000 is awarded. Land Council, the questioning the said seeking enhancement of the said amount, the wife is before this court. Land Council appearing for the petitioner, wife submits that the income of the husband is 2 lakhs, gross salary is 2 lakhs, and the maintenance that is awarded is 30,000, which is a meager amount. In that 13,000, 3 people have to live. The amount that is awarded by the tribunal is not a reasonable amount, and with that amount, they will not be able to meet the monthly expenses. Next paragraph. Land Council appearing for the respondent submits that the gross salary is 1 lakh, 2 lakhs. Of all the deduction, the take-home salary is 1 lakh. It is submitted that the submitted that the husband is taking care of the educational expenses of all the both the children, and apart from that, and earlier he has paid 25,000 per month. It is submitted that he has to take care of himself, his aged old parents, and the amount that is awarded by the tribunal, by the family court, is a reasonable amount, and no enhancement is called for. Next, having heard the counsels on either side, there is a material law record. Undisputedly, the income of the husband is gross salary is 2 lakh. According to him, after deductions, 1 lakh is the take-home salary. Except the statutory deductions, the court cannot consider all other deductions. There are wife and 2 children are dependent on him. The husband is taking care of the educational expenses of the children, right from the house rent, everything. The wife has to pay and also take care of the day-to-day necessities of the children. In the considered opinion of the court, granting an amount of rupees 10,000 each to all the 3 petitioners would be an appropriate amount. Accordingly, this court is passing the following order. The order impugned dated so and so is modified. The husband shall pay an amount of rupees 10,000 each to all the three petitioners. That is an amount of rupees 30,000. Number two, he shall also take care of the educational expenses of the two children. Yes, accordingly, the petition is disposed of. Partly
Well, it's
allowed.
the payment date may be mentioned, my lord, from when he is liable to pay the payment, my lord. Let it be from the petition before the trial court, my lords.
That's how it will be. You don't have to mention.
Specifically, it is mentioned they will take advantage of it, that they will take from the
The amount is as per from the date of IA. Whatever amounts that are already paid shall be deducted from that amount.
May I request for a time frame, my lords? May I request for a time frame for the payment, my lords?
The arrears shall be cleared within a period of 3 months from the date of receipt of the copy of the order.
Very grateful, my lords.
Cell number 2, Manjunath MR for petitioner.
Respondent in this case, my lord.
Where is the counsel for the petitioner?
Petitioner counsel is not present. They have obtained the interim order in the month of February 2024. Thereafter,
No
they are not.
representation on behalf of the petitioner. List this matter for dismissal tomorrow. And what about the objections?
I'll complete this today.
Office objections shall be complied with by today.
Please.
Yes.
Cell number 3, Matthew PM for petitioner.
Yes, come before this honorable court on
Amaya.
5/7/25 to complete the office objections. There was some BP fluctuation for me, so I couldn't attend it on time. It got dismissed on 22/7. It may be reinstated. I just complete the office objections, Lordship.
I number 2 of 25 is filed. So we call the order dated 22/7/2025. Have you compared with the office objections at least now?
It was complied in part. They won't give the file because
Pending consideration of IA number 2 of 25, the petitioner shall comply with the office objections. If the office objections are not complied with, IA will not be considered. Tomorrow, but tomorrow he shall comply with.
after vacation, 1 week time may be granted. 1 week because the file won't come down, Lordship. That's the biggest problem.
This is matter after vacation.
Okay.
Cell number
This is a
4.
matter on the reopening day.
Yes.
By the time the office objection shall be complied with.
8. Cell number 4,
Petitioner, my
Ali Shantappa.
lord. In this matter, I appeal for the respondent.
Prabhu Tungi.
Yes. Yes.
Objection in objection.
Where is input order?
Challenging the order passed to the court, additional of family court.
Keep that mic and switch on the mic. Where is the input order?
Page number 20, my lord.
Page number 20 is your MC petition. This memorandum of settlement under section so and so.
No, my lord. Today, being the last para, my lord. Today being the last civil working day and the as copy of the advancement is not served to the JDR issue of the warrant.
Please
with
come to
post-
the prayer. What is the prayer you are seeking?
If my lordship permits, my lords, I will make.
To quash the order passed by the 4th additional principal judge family court dated 24/2/2025.
Please,
When I
ma'am.
say where is the impugned order, you have to show this order dated 24/2/2025. Where is that order?
Please, ma'am. Lord, petitioner and respondent, in the terms of settlement between the petitioner
Where is
and.
the 24?
This is the order what they have challenged.
How can they challenge that order?
Yes, Lord. That is true. In fact, my lordship has dismissed their earlier writ petition. What happened, my lord, which is produced, my lord, the annexure, page number 39, my lord. My lord, this writ petition had been filed by, my lord, the present petitioner herein through some other person, which has been dismissed with, my lord, 25,000 cost. Again, my lord, he come up with this petition, my lord, seeking to set aside the same, my lord, the order. May I take, my lord, page number 14, my lord, what they have sought in the, my lord, the earlier writ petition.
And how this section is numbering when there is no order? There is no order impugned in this.
This writ
Memorandum
petition,
of settlement has to be set aside.
Lord, this writ petition is
Where
filed.
is that order you are
That,
referring
my
to?
lord,
Page
the-
number?
my lord, page number 39 is the, my lord, the earlier order. 40 is, my lord, the relevant portion. May I take, my lord?
Page number 39.
39, my lord. Their
39
petition.
of which paper?
My lord, their petition, my lord. Writ petition number 17335 page number 39, my lord. In page number 40 only second prayer, kindly see the, my lord, the second prayer. What they have sought is, my lord, the certiorari quashing the entire execution
Oh,
proceeding.
I remember this. Report filed by a caretaker.
My lord, now, my lord, the father himself has come before this. Earlier, he set up, my lord, that caretaker. My lord, since this honorable court dismissed their writ petition, now, my lord, only to prolong the execution petition, again this writ petition is filed to challenging the, my lord, the same order, which is, my lord, in fact, my lord, the memorandum of settlement clearly, my lord, the mentioned, my lord, the husband should vacate the house. Since, my lord, she has purchased the house, she has paid the money, even still, my lord, she is paying the, my lord, the EMI. I have produced all these documents along with, my lord, my objection.
Can you maintain this writ petition with this prayer? Where is order?
My lord, kindly pass on. Senior is
pass
coming,
on?
please, sir. Senior, now, portal number 1 is there, my lord. Please kindly pass on.
We will know 25,000 is over. Now we will impose 50,000 cost. And whether that, just find out whether that 25,000 cost is paid to the legal services authority. Verify.
Serial number 5, Arun Govindraj for petitioner.
My lord, in this matter, my lord, the copy was just served to me very recently, my lord. I have no instructions to appear, though the copy has been served. Kindly have this matter after vacations, my lord.
No, the difficulty is this. There's a mutual consent.
Impugned order.
No, the impugned order is, no, the decree of divorce has taken place, my lord, in the year 2022. Mutual consent decree of divorce was passed. The husband, my lord, said that he had temporarily relocated to Chennai. He said he would come back to Bangalore and start living, after which we would have 50% of custody of the children. On that assurance, my lord, I agreed to him having custody of the children during vacations and weekends for 70%, and I will have 30%. That arrangement has continued for the last 3 years. My lord, he's refusing to move back to Bangalore.
Come to that,
Yes.
that part where
But
it is.
the clause, my lord, is at page number 71, my lord. In page 71. Lord, may I read, my lord? The parties agree that the first petitioner shall have custody of the minor children until the second petitioner relocates to Bangalore. The second petitioner shall have unfettered access to the children during such time, taking into consideration the convenience of the parties and children. In the event the second petitioner relocates to Bangalore, both petitioners shall have equal and joint custody over the children. The parties further agree that the children shall remain in the city of Bangalore, Karnataka till they attain majority. Next para 5. Both parties further agree that when the second petitioner also becomes resident of Bangalore, custody of the children during weekends and school vacations shall be shared equally between the parties. When the second petitioner lives outside of Bangalore, he shall be entitled to 70% of the children's custody over weekends and vacations. The arrangement of custody during vacation shall be on mutually agreed terms by both parties taking into consideration.
No.
Yes.
No, in this memorandum.
Yes.
One, when he relocates.
Yes.
The other para 5 deals with when he has not relocated himself
Correct.
to Bangalore.
Correct.
So whatever is there in 5.
Yes.
Will operate.
Lord, kindly see the understanding between the parties. There were emails exchanged between them.
So that we will not.
Prior to the.
No. As per this.
Yes.
Now you give him whatever is the access.
Yes.
As per this memorandum.
That's what's
happened. When he has not come and relocated to Bangalore.
My lord, the understanding was he would relocate in 2022 itself. It was on that basis, my lord, we entered into this
Please
mutual
read
consent
fine.
decree.
Please read fine.
Yes, my lord, when he relocates, both parties further agree that when the second petitioner also becomes resident of Bangalore, custody of the children during weekends and school vacation shall be shared equally between the parties. When the second petitioner lives outside of Bangalore, he shall be entitled to 70% of the children's custody over weekends and vacations. But it's perfectly clear if it's outside Bangalore. But the understanding was that he would move back within 3 months.
Where is that?
But he was living in Bangalore throughout.
Where is that?
No, that's not an email between the parties. But may make,
Not what is
may make
binding
this
on the
submission.
parties.
No,
What is binding is the agreement that is entered.
There are subsequent developments that have taken place. My lord, after the decree was passed, last year, my lord, the father takes the children to Chennai for vacations, does not bring them back at all. I file a habeas corpus petition before this honorable court.
If he's doing something
Yes.
contrary to this, you have a
Therefore, my lord,
mechanism to execute this.
I filed a habeas corpus petition. Children said they want to live with me in Bangalore. Order was passed, my lord, by this honorable court. I placed that also on record. My lord, thereafter,
What do you expect the court to do?
my lord, I have filed a petition before the family court now for modification of the terms that
How
this
can the court do the modification of the term?
under section 26, my lord, it's permissible for.
No, it is a joint memorandum
Correct.
of understanding.
Correct.
How the MOU both the parties have signed.
Yes.
Now, how the court will alter this?
No, the court has the power.
Let's see.
Yes. Any terms, change in custodial terms, the family court under section 26 has the power to alter the terms.
So let's see give the act.
Section 26
Yes, let's see.
of the family court. Even after passing the decree, court has power to make modifications. This is settled law. This has been interpreted by the Honorable High Court of Karnataka. 2 division benches have considered.
No, it is always a court will take into consideration the interest of the party.
Correct.
And if that is the case, so every memorandum of understanding that is entered between the parties, a court can alter the conditions.
That law provides for it. Section 26. Hindu Marriage Act.
It is a guardianship and what's act.
Divorce petition. It was in a mutual consent divorce petition. These terms were agreed upon.
Let's read.
Yes. May I read section 26?
Uh.
In any proceeding under this act, the court may from time to time pass such interim orders and make such provisions in the decree as it may deem just and proper with respect to custody, maintenance and education of minor children, consistently with their wishes wherever possible, and may, after the decree, upon application by petition for the purpose, make from time to time all such orders and provisions with respect to the custody, maintenance, education of children as might have been made.
It is.
Yes.
As far as the welfare of the children is concerned,
Yes.
it won't remain static. So basing on the requirement,
True.
The court will consider and keep on passing the orders.
True.
Now, what is the difficulty of the mother if the father doesn't relocate?
After they took the children away last year and the habeas corpus petition was filed, the daughter is now refusing to go for any amount of time, not just 50%. The mother is convincing her at least 50% of the time you go over. She's a 15-year-old girl. And Manoj, this is recorded by the Honorable High Court in the habeas corpus proceeding. When the daughter was brought to Bangalore, she was under police custody. The children were brought to Bangalore and the father also was present before the court. When the court inquired with both the children, they said they want to stay with the mother, they want to go with the father. Therefore, having regard to these change in circumstances, I filed a petition for modification of the terms. I'm not seeking that the father should not have custody at all. I'm saying I'm a working lady also. I agreed to these terms on his undertaking that he would relocate to Bangalore. He's been in Bangalore throughout. Only for 1 year, through the entire course of our marriage, he was staying in Chennai. Now, I'm a working lady. He wants to give me 30% of weekend, which is about 3 hours in a weekend. He wants to give me with my children. And for summer vacation, he takes for 45 days. I get 15 days.
But that's what you agreed.
That was because of the understanding. We have emails. Along with the memo.
No, the thing is, as per some understanding.
Yes.
The father must
Mutual
have parted.
consent.
No, it's the second petition shall bear all medical expenses or whatever the term.
Yes.
He has parted with something in the mutual consent divorce.
Yes.
Now the mother will say that the children are not interested to meet the father, and the court will again change everything.
I'm not saying that. I'm saying, I've convinced my daughter at least 50% of the time, vacation time, she has to spend with her father. She's a 15-year-old girl. She's going to 10th standard, my request, only one email, this is before the divorce was filed. The reason for me to agree to that 70-30% was this. At page number 1, my lord, of my memo, the email dated 30th November 2021, my lord. Memo. I've just filed a memo now, my lord. My lord has the memo.
Yes, I'll look into that.
My lord, hi so-and-so. Thank you for clarity over our call today. As discussed, kids and I will continue to live in Bangalore. God willing, you will move to Bangalore by March based on change of job. Finance, you will continue to support the children's education and related expenses and medical expenditure. Towards my financial support, you will not be able to provide anything. The children will spend equal time between both our homes. I will revert with the draft after speaking to my counsel. He agrees, my lord, on the next page. Thank you for capturing our conversation. Like I mentioned, let us start the framework once my offer comes through on paper. No, it is on the basis of this that I kindly appreciate my position. He earns 4 lakhs a month. I get 35,000 rupees a month. Bulk of the children's expenses I am bearing. If he was supposed to move to Bangalore, but not 50% of the time children would live with him, he would take care of their expenses 50% of the time. Now I'm taking care of all their expenses, everything, Monday to Friday. Saturday, Sunday, children spend with him. 70% of the weekends, children spend with him.
He'll be coming to Bangalore.
He comes to Bangalore.
That is also not a small task for him.
We were all living in Bangalore together. He wants me instead to move to Chennai, along with the children. Children don't want it because they've been brought up in
For
Bangalore.
example, if he moves to Bangalore, what will happen?
50%. Equal custody during weekdays, weekends, all times. It also reduces my financial burden. 35,000 rupees is my salary. 4 lakhs admittedly is his salary per month.
How it reduces?
Sorry?
How it reduces your burden?
The 50% of the time when the children spend over there, my lord. Now, Monday to Friday, I'm taking care of all their expenses. Every single expense, food, clothing, everything is taken care of by me. He only pays for their education, extracurricular activities. And that too what he approves of. And I've also sought, in modification, I've also sought for maintenance. That's an aspect the family court will deal with. Kindly appreciate, holidays, I get no time with the children. Absolutely no time. And this was an assurance by the father that he will move back to Bangalore. And so far as the right of the family court, to alter the decree, I have placed on record 2 judgments of our High Court, 2 division bench judgments.
But right now, let her get instructions. So it's been continuing. No urgency for this. Immediately after vacation, we'll hear the husband also and file an order.
Vacations are now going.
Let him have the Mrs. matter immediately after vacation. Immediately after first or second day or third day of the vacation, give that.
May I also make one request? Since the learned counsel says she does not have instructions, I will take out emergent notice also to the respondent.
Petition is permitted to take out emergent notice. It is submitted that the learned counsel has served the copy of the notice on Geeta Devi MP. It is submitted that she still has to get instruction. Alternatively, issue emergent notice to the respondent.
Please.
Yes.
Cell number 6. And 10.
Yes, the respondents, my lord. In this matter, my lord, while admitting in the writ petition on 2nd July 2018, 3,000 per month maintenance was granted to respondent number 1. Towards respondent number 1, my lord. That is
Where is the petitioner?
Hemalata Mahishi.
You filed
it's only
IA
for the release of the amount, please, my lord.
No representation for the petitioner. IA number 2 of 25 is filed, seeking release of the deposited amount in favor of the respondent number 1. Accordingly, IA is ordered.
Cell number 7. Sudeep Bangera.
I have filed the recalling application, my lordship. Order dated 22/7/2025.
Why it should be recalled?
My lordship, I have completed the office objection, my lordship. But some office objection
Office objections to be complied with means all the office objections to be
Yes,
complied.
please, my
You
lordship,
can't
that
do
is-
it part of it.
No, the certified copies produced before this honorable court, my lordship, A and B, that is annexure A and B, that is
At least
judgment
by
copy,
today,
my lordship.
At least by
And
today, have you complied with all the office objections?
Yes, my lordship. One objection is required to be clarified, my
MOA,
lordship.
so and so. Where is that? What are the office objections? The not complied.
That is
The following
office
objections that to
objection,
be
my lordship.
completed. Jurisdiction to be stated. Para numbers
I have
to be
stated,
stated.
my lordship. I have
Bearing
stated.
number to be stated. With these many objections, you say that you have complied and I
Yes,
have to recall the
yes,
order.
my lordship, I have complied, my lordship. Sorry, my lordship, I have complied. Court fee paid, jurisdiction also stated, my lordship. And events of the chronologically, that is also taped copy, I have filed. And the index also I have filed. Para also mentioned correctly, my lordship. And annexure A and B is the common order, my lordship. That is
Office to correctly state what are the objections, office objections still not complied with. This matter after. Yes, next.
Serial number 8.
1 week time, my lordship.
Next.
Serial number 8.
But I appear for the respondent in this
Being
case.
judged.
Yes.
On the previous occasion, your lordship had directed me to place on record. Ma'am, Courtmaster.
Whether the
Court
college
master.
fees is due or not.
Courtmaster.
Take that.
The daughter in question, my lord, has graduated on 23/7/2025. Those photographs I have produced at page number 12 and 13. The lordship may kindly have a look. So there are no fees that are due on her graduation. She is now working. She works with a multinational clothing company in the UK. The son, my lord, he, as my learned friend had submitted on the last occasion, he's studying in NIOS. He does not go to school. He's 17 years old. He does not go to school. Kindly turn to page number 14. Your lordship will see the school fees, the NIOS fees for secondary courses, senior secondary courses. On page number 14, your lordship will find the top 1/3 of the page. Secondary course, senior secondary course. It's 2,600 rupees a year. These are the NIOS fees, since he does not go to a school. Therefore, the maintenance that has been ordered by the civil judge, even if your lordship were to turn to page number 30, the impugned order at page number 30.
Yes.
A typographical error has been made much of. Kindly turn, sorry, the impugned order is at page number 65. Page number 65, it's the last document. Those documents at paragraph number 7. The petitioner has, my lordship has it, page number 70. The petitioner has heaped up the allegation against the respondent, pointing at the respondent that owing to sole irresponsibility, the respondent marital relationship is not cordial between them, whereas the respondent, negating each and every allegation, contended that the respondent is the caring husband and father, but the petitioner is at fault in the marital relationship. All these allegations and counter allegations are a matter of trial. Paragraph number 9, kindly switch to paragraph number 9 on the facing page. Notable to mention, my lordship has it, notable to mention that both parties have filed the affidavit of disclosure of the assets and liabilities along with bank statements. From the affidavit filed by the petitioner, it emerges that the petitioner is earning a salary of rupees 43,000. This is her affidavit per month. Whereas the affidavit filed by the respondent discloses that the respondent is fetching a salary of rupees 4 lakh per month. It is to be noted that the respondent states that all the educational expenses of his both children borne by him and the said aspect of the facts reflect in the bank statement and the education loan statement produced by the respondent. This has already been considered by the civil judge. Kindly turn over to page number 72, paragraph number 10, which has been referred to as paragraph number 12 in the impugned order, in the operative portion of the order. The respondent states that apart from the educational expenses of the children to be borne by him, he has other liabilities of payment of loan expenses towards the treatment of his mother. Kindly pause here for a moment, my lord, and turn to the paper book which I have submitted to your lordship at page number 17. 17. My mother has been admitted to Nicosia Dementia Village and Alzheimer's Hospital. In the past 5 months, the bill has amounted to rupees 4,50,000. Those bills I have produced at the subsequent pages. So the part of the marital discord that arises is because the petitioner before your lordship had abandoned the respondent's mother, although she was suffering from dementia, and locked up all the bedrooms in the house, leaving her alone with a carer. So what would have been a cost-effective solution to look after the mother-in-law has turned into an extremely expensive proposition for them. So he has no choice but to maintain his mother. Continuing, my lord. The respondent has produced the hospital bills, residential statement of his daughter, school fee receipts of his son, bank statement, education loan statement. All these documents at this juncture indicate that the educational fee of both children, loan installments, are borne by the respondent, and even the expenditure towards the treatment of the mother of the respondent as well. Now, on the previous occasion, counsel for the petitioner had submitted that he wants the educational expenses to be continued to be paid by me. But now that my daughter has graduated on 23/7/2025, there is no question of me paying expensive fees for her in the UK. And as I have brought to your lordship's attention at page number 14 onwards, the NIOS fees is about 2,600, 3,000 rupees a month, or about 200 rupees per 200 rupees per month, or about 3,000 rupees per annum. If this is what I'm expected to pay, certainly I will bear this cost. Now, the amount that is due. The amount that is due, I have calculated the amount that is due under the order that is impugned before your lordship. That amount, your lordship will find at page number 2 of the memo. The civil judge directs me to pay a sum of rupees 55,000, and this is not some figure that the civil judge has pulled out of thin air, because he says in paragraph number 11 of the impugned order, the bank statement pertaining to the petitioner discloses salary earned by the petitioner as well as transfer of rupees 55,000 in the certain months of the year 2022 and 2023 by the respondent to the petitioner. Even that fact is admitted by the petitioner. It is to be noted that the bank statement of the petitioner ranging from the year 2020 to 9/1/2023 indicates transfer of a considerable sum of amount from the respondent to the petitioner. As noted above, the bank statement pertains to both parties, reflects in certain months of the year 2022 and 2023. The respondent has transferred an amount of rupees 55 to 60,000 rupees and even more amounts in certain months consecutively. Thus, all these materials at this juncture indicate that the petitioner, apart from a monthly salary, receiving rupees 55,000 per month. So all in all, she gets up more than a lakh. From the material before the court, it appears that there may be some arranged or understanding between the petitioner and the respondent that towards the maintenance of the petitioner, the respondent was paying the month sum of rupees 55,000. So this is a well-reasoned amount that he is well-reasoned in the sense that I am also aggrieved by this amount because she is earning, but nevertheless, it is a well-reasoned amount. Now coming back to this,
So what is the salary?
my salary, my lord, I work in Turkey. So my salary, though it may be 4 lakh rupees a month, I have to pay in that currency also. And I am
the purchase parity of that compared to India.
My lord, it's about my monthly income is 3,73,000 per month. I have to pay for my mother, I have to pay this maintenance to her. I have to pay huge bank loans that I have taken to educate my daughter in the UK. That there is no mention about. Now that I have paid for my daughter's education, my son is not being educated at all. She has no use for me. So therefore, grab whatever money can be grabbed from the respondent, and then have the divorce petition decreed. This seems to be the game plan. This seems to be the playbook. And right now, when a sum of rupees 55,000 is awarded, they do not want it. And even if your lordship were to see,
What about this dues?
my lord,
What about the dues? Why you did not pay 17 lakh 5,000?
70 lakhs, 17 lakhs 5,000 I am paying. Now a sum of rupees, I have paid a sum of rupees to her. I have paid a sum of rupees 12 lakhs 20,000 already. I will clear the remaining. I have no difficulty in clearing because I have paid huge sums of more than 75 lakhs towards my daughter's
Going to
education.
clear this 17 lakh 5,000.
Give me till the end of this year, I'll clear it. By December 31st, I'll clear it.
Lord, I'm sorry, I think my learned friend obviously has not received instructions from his client. 16 lakhs 30,000 rupees is what the mother has paid towards the daughter's education on June 15th of this year. This was on pain of the university informing both parents that the daughter will not graduate from college if the amount is not paid. Kindly see page number 6, it's the page number 5 is the University of Leeds statement. Your lordship has page number 5.
No, that's why he just said daughter has paid. Paid from the daughter has got the money. He didn't say so.
No, kindly see page number 6. The email sent by the university our records show that you have outstanding tuition fees. A statement of your account is attached. That was at page number 5. If you're planning to attend graduation ceremony this summer, your payment must be received by Friday, 20th June. Until this debt is paid, we will not be in a position to issue your degree certificate or transcript or confirm your award to third parties. Therefore, what mother had to pay on the next page, page number 7, 12 lakhs, your lordship will see remittance details. Remittance amount is 12,54,467.
Where do you find that?
No, page number 7, my lord, your lordship has payment.
Amount,
There's a table.
Amount.
Remittance amount is 12,54,467 was paid on 19th of June. And then the confirmation from the university on page number 8. On 20th June, originating amount 12,54,467, translating to 10,475. Lord, on the next page, I've made one more payment, my lord. For the daughter's visa was expiring for the education for graduation. On 7th July, Great British Pounds 3,000 has been paid. That translates to, in my affidavit I have stated, is 3,60,000, my lord, paragraph number 4. 3,60,120. In all, my lord, I have paid 16,14,587. And so far as son's education, my learned friend, my lord, very eloquently said that the mother is trying to take money. Kindly see page 36, WhatsApp chats between the petitioner and the respondent. At page 34, I'm sorry. He sent 35,000 rupees to my account. Page 34, 34. On 11th September, my lord, page 34. The lordship has.
Yes.
On 11th September, my lord, the respondent transfers to my account 35,000 rupees, to which I respond, Captain, why are you suddenly rerouting Dhruv's tuition fee via me? You have always been paying for the education directly. Sorry, my lord, it's on the next page. Continues. Why don't you send Dhruv his pocket money directly to his own account? To that, the response is at page number 36. Philidor, I agree, I was paying all children's expenses directly, but you have filed petition in court and asked for money and used Dhruv and Tanaya name and their expenses, and the court states I have to pay you for their expenses. So the money is being sent to your account to pay them. Lord, he is trying to misread that para 10 and 12, the confusion in the order of the court, where the court says para 10 court records that the father is paying all the expenses, but at para number 12, operative portion, court says subject to observations made in para 12. There are no observations made in para 12.
One thing is clear.
Yes.
The girl's education is complete.
Now complete.
The father did not pay.
But the 16 lakhs, yes.
Apart from that.
Yes.
So nothing. Then when it comes to the son's education, whatever of the expenses that he will bear.
He'll have to pay. Yes.
He will bear.
Directly to the teacher.
And
yes.
55,000 what is granted by the court will confirm.
Yes.
Lord,
that is all I want.
Kindly see the paper book that I have given your lord, submitted to your lordship.
Yes.
The last page. From the last page, we will go backwards. These are all sums that your lordship will find. These are all sums that are being paid directly to my son for his expenditure to various people. They do not deny this. All these sums of money, they're not small sums of money. There are small and large sums, but generally they're not small sums of money. In all, I have paid for my son's education more than 4.5 lakh rupees. So now they are saying that, look, this you are paying, you are paying it directly to your son. It even continues to this day. Kindly see the dates. The last date that I have paid for my son's education is 5th of May.
Without going into all this.
Let the family court decide that.
No. What you please find out from your client.
Yes.
What exactly are the educational expenses of the child? A lump sum amount he will pay instead of paying every day 20,000, 50,000, 5,000, 7,000, which has there is no accountability to this.
He was paying directly to the teacher, not to me, my lord. He was paying to the tuition teacher.
No, please.
Very well, she's here.
Ask her what is the amount.
They do not deny the sums of money that I have paid towards the education of the daughter.
No, instead of you all the time paying some amount of.
No, they're treating these proceedings as if it's some recovery proceedings against fees that are paid to my daughter. does she not, first of all, I will get instructions on this. And second of all, does she not have a responsibility? She has herself not produced a bank statement.
My friend does not even challenge the order. I don't know why he's arguing as if his writ petition. Petition is mine. I'm asking for
Even
enhancement.
so, now you're before the court and you're asking.
Sir, you cannot challenge the order.
No, before this, you're before this court asking for some areas. This is not an area. This is not a recovery suit.
No, I'm not even seeking that.
Now he has asked for areas.
I'm not.
I asked you, when you filed a statement before the court
Yes,
saying that 17 lakhs for areas,
Yes.
I asked you why you didn't pay.
I have paid it.
I asked you, he didn't ask, so he didn't request the court for the arrears.
Now they're asking for areas of the daughter's education.
Because you said you have already paid.
Yes, my lord, I have paid it.
But you have not.
I have paid it 76 lakhs 1,744.
No, entire educational expense. Please come to your, let's not, there should be a specific statement, Mr. Counsel.
Yes, my lord.
1 minute. Please come to the memo that you have filed.
Yes, ma'am.
What did you say? The party's daughter paid the last installment of her fees, 10,445 so and so.
Yes.
For a UK bank account. You do not say that you have sent her this amount.
1 minute. I will demonstrate to my lordship.
Yes.
Kindly turn to page number 59, my lord.
Yes.
Does the Lord have it? It's an email. It says payment confirmation. Yes, my lord. Payment confirmation.
25th August.
Yes,
2022.
Kindly turn to page number 62 because it goes in reverse chronology. There's 9,000 pounds in the last email. Total paid today 9,000 GBP. Add to that the previous page.
Transaction date 14 September 2022.
Yes, my lord.
We are talking about this year and you are referring to something of 14.
Totally, I have paid
We
a
are
sum
not
of.
on that, Mr. Counsel. We
Yes,
are
my
not
lord.
on what you have totally paid. Educational expenses, according to you, you are paying.
Yes.
Court has directed you to pay the educational
Yes, my
expenses. Your submission is that she has completed her education.
Yes.
Now the last transaction, that is the last installment of the academic fees, was not paid by you, was paid by the mother. That's the issue. We are not on whether you have paid earlier or not. Is not question. Court is not questioning you. They are also not. There is no dispute on that. They also say you have paid. Last installment you have not paid. It's a simple submission. For that you also do not deny because you don't file any document before the court.
I've got it only now.
No, you have said so. Even in your 5, you said the party's daughter, Tanya Naveen, paid the last installment of her fees. Very cleverly stated. It is, you didn't say that I have paid. You said daughter has paid. Where will the daughter will get the money to pay this? Please come.
I will seek instructions on this, my lord. There is definitely a transaction for this.
Will the learned counsel for the petitioner shall get instruction. Now, learned counsel for the petitioner mother submits that by filing a document before this court. The last installment of the school fees amounting to 12,54,467 is paid by her, which she has transferred and the girl has paid to the college. Even in the state memo that is placed before the court, the father states that the party's daughter, Tanya Naveen, paid the last installment of her fees of 10,455 pounds from a UK bank account in July 2025. On the face of it, it is clear that the wife had transferred and the daughter has paid. But still, learned counsel for the respondent father submits that it is he has to get instructions whether that amount is paid by the mother or the father. List this matter tomorrow.
Cell number 9, criminal hearing. Cell number 9.
Ian, ID. Ian, ID.
Yes.
So I'm sorry, my request Friday, my lord. Tomorrow I have
Friday.
Great.
Yes, next.
This is a matter where your lordship was kind enough to take it in the chambers. However, the parties did not
Yes, what is this matter about?
Because this regards the granting of interim maintenance to the respondent wife.
Where is it? Where is it?
Milord's impugned order is at page 69. May I take your lordships to the reasons part, Milords, page 71. Page
Pay
71.
20,000 per month as an interim maintenance. Let's read from the reasoning part.
Milord's reasoning part, may I just,
Or else we'll do, like, because it's not there, I'll post it for, as part of, on, tomorrow. On the last occasion, when the matter was, when the parties were directed to appear before appear in the chambers, there was no representation on behalf of the council and the party. Hence, this matter was directed to be listed before the court. Today also, there is no representation. Heard the counsel of the petitioner in part, listed as part heard on Friday.
Friday, Milords?
Or tomorrow. Tomorrow.
Milords, tomorrow I have an inconvenience. Friday is
Friday
or
may not be
Monday?
possible because Friday is a half day.
Sorry, Monday is. Okay, all right, tomorrow.
Yes.
Milords, after 2:30, because I have a.
Ask her a Passover, ask your colleague to ask a Passover.
Great.
Cell number 10 adjourned. Cell number 11. MC Ravi Kumar.
Petitioner, Your Lordship. Lordship, I challenge the order passed by the family court at Annexure A.
Yes.
Lordship, the respondent, who is the wife of the petitioner, she had already filed a petition before in the DV case, and the interim maintenance was ordered.
How much?
2 children, 20,000. 20,000 was ordered. No.
Are you
again,
paying 20,000?
I have been paying to the children. Maintenance for her was not ordered for the reason that, Your Lordship, from 2014 till 2019, when after the marriage and after there was a dispute, in the house, she had left the house in the year 2014. But the petitioner and respondent, they had an understanding as a husband and wife, but she was residing in her parents' house. During that period, Your Lordship, from 2014 to 19.
No, this maintenance is granted to whom?
Maintenance, she asked for maintenance.
His case?
Yes, she asked for maintenance.
Not granted.
But only education expenses is granted.
So let's not go into why it is not granted to her.
No, why this order we have challenged, it will not arise to grant because, Your Lordship, from me, when we resided together, she has taken more than 5 crores rupees. She has that amount. That is what I have narrated in my petition, Your Lordship.
What is the evidence?
What's it?
Evidence.
Evidence, Your Lordship, may kindly peruse Annexure H.
Have you filed before the court?
Your Lordship, this we have pleaded. We have pleaded.
Pleading is not sufficient. You have to prove it also.
No, she has admitted, and we have pleaded this aspect before the court that she had taken the amount. Now, the brief facts is, Your Lordship, what had happened is when the family members had entrusted me to look after the business, all this had taken place. Till she took the money, she was a loving wife so far the respondent is concerned. In 2019, when once I demanded to return back the amount, everything was bank transfer, where loan was obtained for the purpose of business, where she had mesmerized me, Your Lordship, that business will be started, and she had taken all my amount. When I demanded, she became cunning. When I insisted, your lordship,
Because all these questions, without the other side being present,
yes,
we cannot pass
I
orders.
what,
Notice to the respondent.
yes, what I am praying is the order what is passed, the operation of the order may be stayed. No, because your lordship, she is getting nearly 1 lakh from the amount what she is having. She has not filed her assets and liabilities, which are very important, your lordship, to come to the even pay the additional maintenance.
Have you filed your
I have filed my the court in this impugned order. It has stated it is violation of the order passed by the.
What is your income?
Your lordship, I was thrown out of the house. Now I am doing a real estate business. Somehow I am earning my income. With that I am paying the amount.
How much
I have.
How much you're earning?
I am earning some 30 to 40,000. Where 20,000 I have to pay the children. I don't have anything. I was thrown out of the house because of these deeds.
That's why if you read the order of the court first, then the facts will come.
Yes, your lordship.
So that is more relevant than telling all these facts which are not relevant.
So these facts I have stated.
But first of all, we have to look at why, on what basis court has granted. Then the court will
Yes.
understand. Please come to the order. We will come to paragraph number 21.
In the affidavit of assets and liabilities filed by the petitioner husband, he has
You
shown.
have shown that per month, household expenses 30,000, medical expenses 5,000, transportation expenses 10,000, litigation expenses 2 lakhs
Yes, your lordship.
per
that,
month.
That assets
So
of.
it's coming to how much? 2,45,000 is your income or your expenses.
Your lordship, 30,000, 10,000, 5,000.
And 2 lakhs.
Litigation expenses, your lordship. What I have mentioned, that will not give any criteria so for litigation expenses.
But you have to pay unless and until you have the money. How will you pay?
That also would be pending, your lordship, so for paying the litigation expenses, where your lordship, number of cases have filed against me. I have narrated it in my petition. Your lordship may kindly peruse para 16. After 2019, your lordship, these are the cases filed by me against the wife: criminal case, dowry harassment case, recovery case. All these cases. In spite of that, your lordship, she having the booty, your lordship, she wants to file a application. Main thing is, when court directed her to file assets and liabilities and bank statement, she has not filed it. It is presumed that she is having that amount.
Please read the order, Mr. Counsel. Read the orders so that the court will understand what are the facts.
Yes. Medical expenses rupees 5,000, transportation expenses 10,000, and litigation expenses rupees 2 lakhs. He has listed the proceedings pending between them. That is criminal miscellaneous 67, wherein interim maintenance of rupees 10,000 is awarded to each daughter. PCR number 3952 of 2019, writ petition number 2514 of 2021, OS number 2156 of 2019, CC number 15469 of 2022, CC number 26465 of 2022, criminal petition number 90 of 19 of 2022, PCR number 14470 of 2019, CC number 38552 of 2022, writ petition number 32186 of 2019, and criminal petition number 8014 of 2022, para 22. He shows his both daughters' name in column E children details. With reference to details of his income, he has shown as not applicable. In the column of particulars of respondent wife, he has shown her educational qualification as BA, MA, HR, PG, DIR, PM, postgraduate diploma in industrial relations and personal management, working in St. Joseph's College, and she is a share market advisor and earning approximately rupees 50,000 per month. In the column of details of his liabilities, he has shown rupees 4.6 crores from family members, and the same was taken from him by the respondent, rupees 1.5 crore from his brother-in-law G. Gangadhar, and rupees 1.4 crore from L&T Finance Limited. For more than rupees 60 lakhs has been paid to L&T EMI towards their house, and the balance is more than
Agreed with the order passed.
rupees 5 crore.
I number 6 in MC number 1511 of 2020, dated 24th March 2025. whereby the court had granted 10,000 as maintenance. The husband is before this court. Then counsel appearing for the husband superstar in the domestic violence case already court had granted 20,000 to the two children, and he is paying the maintenance. According to the wife, her income per month is 50,000, and she has not pay, placed before the court. She has not filed a statement of assets and liabilities. In spite of that, court has granted maintenance of 10,000. Next paragraph. This court has having heard the land counsel, the petitioner peruse the material on record. In paragraph number 27, the court makes a specific reference to non-filing of her statement of assets and liabilities. When the wife had not filed a statement of assets and liabilities as envisaged by the Honorable Apex Court in Rashish versus Miha, the court has to take an adverse inference. And this court has observed that without there being any material with regard to the income of the husband, still the court had granted 10,000. In these circumstances, there will be stay of all further proceeding. Pursuant to the order dated so and so, petition is permitted to take out hand summons and file a memo to that effect by October 16. By the time the memo is not filed, the stay granted by this court stands vacated. Yes, next.
Then number 12.
Lordship,
And
only
may
the
I
operation of the order, Your Lordship, because I have filed the divorce petition. My petition is filed by me.
So,
Operation of the order.
I only said so.
Yes. I may be served on the council representative.
That also I have said.
Much okay.
Yes. Where is the impugned order?
Impugned order is at page 42 to the next C, my lord. I have filed an application for not maintainability of the proceeding under 125 CRPC by
IA
the
number
by the
5 under
respondent.
section 125 1B. Your case is dismissed, your application is dismissed.
Yes, my lord, my application is dismissed. My
What is-
contention is that
What is the respondent?
until then, let the operation of the further proceedings in criminal miscellaneous be stayed, my lord, because the applications filed under 125 is still pending for interim maintenance
The
till next date at least.
petition is permitted to take out hand summons on the counsel appearing for the respondent and file a memo to that effect. Once a memo is filed, is the matter. Yes, 13.
Number 13. Sanjay Kumar for petitioner.
Yes.
My Lord, being highly aggrieved by the order passed by the
It is
trial.
order page number. Maintenance is 4,000.
4,000 each,
That is how much? 8,000.
8,000.
What is your salary?
My Lord, the petitioner is under medication and is not earning and is running a rented auto, my Lord. My
Please
Lord,
come to the
on
order. How it is discussed by the court. Please come to the order.
my Lord, on 9/5/2020, the ex-wife of the petitioner went along with some valuable items. Kindly see para 18, my Lord, of my petition. The 4 lakhs rupees and site and Indica car, two-wheeler, gold ornaments, jewelers are she's the having illicit relationship with one Mr. Vishal, my Lord. And she went along with daughters.
That will be decided by the court in the later. Now at this stage, we will not go into that. 8,000 is even if you're earning any daily wages also.
She has a means profit from the building which has been registered in favor of the ex-wife. On the very
What is the ex-wife? She is.
yeah on the very same ground she was divorced on 2020 and 2000
ground of adultery.
my,
On the ground of adultery.
yes, my Lord.
Where is that?
My lord, in MC,
Please come.
yes.
Let counsel the petitioners understand. The wife was living in adultery.
MC number
On that
529 of
filed an MC, and the MC was decreed, and the divorce was
529
granted.
of
It is submitted that she is living with the very same person.
and the
In spite of the
petitioner is
same,
not in a financial position to
did,
comply with the
maintenance
impugned
to the wife, considering the submission of the land counsel to the petitioner, they shall bestow of all further proceedings pursuant to the order dated so and so so and so. Same
My
on
lord,
this hand summons.
kindly stay the interim.
16th, you shall file a memo to that effect by 16, or else stay granted by this court stands vacated. Next.
Cell number 14, Dos Sebastian.
Yes.
No. What a interim maintenance of 6,000 per month. My respected submission is that I was earlier working in Regency.
Please use the mic.
Sorry. I was working in Regency College earlier. Because of her complaint, I have been terminated from there. Then, no other avocation I know. I have now started working as a Rapido driver, two-wheeler driver. I am hardly getting about 500, maximum 500 to 600 per day. Sometimes if it is available, depends upon. But whereas the respondent, he is working in ATCO India, that is a multi concern. They are drawing about 4,800, 48,000 per month. There are so many litigations. Hardly we stayed only for 2 months. 2 months.
There is order. No, we will not hear all those arguments.
Yes, Lord.
It has to be part of what
Yes,
has
Lord.
been argued before.
I will just,
yes.
The order is at page, annexure A, he said, annexure at page 261, Milord.
Annexure A is at page 261.
261. The operative portion of the order, Milord, the reasons given, Milord, that is according to para 8, Milord, at page 265. According to the petitioner, respondent is qualified MCA, working as an assistant professor. Per contra, respondent has submitted that petitioner is working in ATCO India with a salary more than rupees 40,000 per month. Then para 9. That on 19 for 2022, the petitioner has submitted her first affidavit of assets and liabilities. She has claimed that he is a homemaker residing at her parents, etc. And respondent is working as a lecturer in PU College Vidyaranipura. It is worth to note that the same affidavit and assets affidavit, petitioner has contended that her annual income is 16 lakhs 80,000 and getting a net profit of 9 lakhs 60,000 per month. Of course, I was working earlier. Because of her complaint, I has been terminated from there. No other avocation, I am using as a two-wheeler driver to hardly getting him. Moreover,
please come.
I have a short for stay. My position is like that.
Petition is filed.
I
agreed with the orders passed in the criminal miscellaneous in criminal miscellaneous in an application seeking interim maintenance in criminal miscellaneous number 205 of 2021, whereby the court had granted maintenance of an amount of rupees 6,000. By the court in the order impugned had observed that that on 19/4/2022, the wife has submitted her first affidavit of assets and liabilities. She has claimed as homemaker, residing with her parents, and the respondent is working as lecturer in the Regency EU College, Vidyaranyapura. In the same affidavit of assets and liabilities, she has contended that her annual turnover is rupees 16,80,000 and getting net profit of rupees 9,06,000 per annum. In the other statement of affidavits and liabilities dated 5/1/2024, she has submitted that she is homemaker, residing with her parents and depending on her aged parents. And she has borrowed loan of 3,50,000, and even today she has not repaid the same. In spite of recording such a finding, the court had failed to consider the same. Why the wife had taken two inconsistent pleas and why she has filed two inconsistent statement of assets and liabilities. And still the court has granted 6,000 in these circumstances. In the light of the above facts, they shall be stay of all further proceedings pursuant to the order dated so and so. Same shall take hand summons and file a memo to that effect by 16, or else the stay granted by this court stands vacant. Yes, next.
Cell number 15, Sunil PP, for petitioner.
Next to A, my lords, is the impugned order. Lords, before I make my submissions on impugned A, my lords, I would like to draw my lords' attention to the material on record which is before the Honorable Trial Court. This is the order, my lords. The trial court has granted interim maintenance to the wife who was earning, my lords, 80,000 per month, which was suppressed by the respondent, and my lords has obtained the order of interim maintenance. My lords, may kindly turn to page number, my lords,
No,
21.
there are two writ petitions. We are looking at the first writ petition 29081 of 2025. Where is the impugned order?
Plus 15 minutes. Cell number 15.
Oh, 15, yes. Where is the impugned order?
Impugned order, my lords, at annexure A, page 37.
Let us
This,
look
my
at it
lords.
first.
Yes, please, my lords. This is, my lords, granting, my lords, the interim order, interim maintenance of 6,000 to the respondent.
1 minute. The petition is entitled for 6,000.
Yes, please, my lords. Lords, this application, my lords, before the trial court has been filed by the respondent on 13/6/2022. Lords, may kindly turn to page 188, annexure X. Lords, as on the date of petition, lords, her own bank account reflects that she was drawing, lords, about 76,826 salary. Lords, may kindly.
So it is 76,562.
Yes, please, lords. And lords, continuously, lords, month on month, lords, the salary.
Till when she is drawing like that?
Lords.
Till which date she is drawing like that?
Lords, she has drawn, lords, this bank statement is up to, lords, 2020 December 2021. December 2021, lords, she was drawing all this salary, lords. Even thereafter, lords, she has been drawing about 80,000 salary.
These bank statements were not placed before the court.
It was, my lords, as on the date of the passing of the
As on
order.
the date of the application, she is not working.
My lords,
As on the date of application, she is not working.
she is continuously working, lords. That is my respectful submission.
Where is that? You are saying that these bank statements of till 2021.
Yes, please, my lord. That is as on the date of your application, my lords.
Application according to you is on 13/6/2022.
13/6, my lords. As on that day, my lords, she was drawing salary of 36. That is what, my lords, is the bank statement. Kindly see the
Yes,
fourth.
no, you said the bank statements are till December 2021.
2022.
Let's see.
31st December 2022.
Where
Lords,
is
the
that
petition
mentioned?
came, it's, my lords, the second page, my lords. After not registered from 6/4/20.
216. Come to 216 is the last page of the statement.
Page number 216.
216.
216 is a different, my lords.
Bank statement, end of the bank statement.
Yes, please, my lords.
Last page.
Up to December 2022.
I'm asking you, where is the last entry of the salary?
Lords, this is a different account, my lords. In this, the amount was not getting credited.
Where is it in the other account?
Kindly see, my lords.
Page number.
Page number 190 onwards, my lords, is a different bank account. Lords, page number 188 and 189 was pertaining to the salaried account.
So salary, when is the last entry?
Lords,
It is on
the entry
1/11/2022.
1/11/2022.
IA is filed.
IA is filed, my lords, along with the petition on 13/6/2022.
No, please come to the order.
Please, my lords. Now, this apart, my lords, ascertained liability was also filed. In that, my lords, she says she has no income. I will draw my lords' attention to.
No, please come to the order first.
Yes, please, my lords.
We'll read the order.
Yes, please. Kindly see, my lords, the observation of the Honorable Trial Court, paragraph number 10, my lords, of the impugned order, page 41.
Come to paragraph number 10.
Yes, please, my lords. The petitioner has filed her affidavit showing the ascertained liability. She has stated that she does not have any source of income, whereas the respondent have income of, so it's by mistake, my lords, it should be 50,000 and 50 lakhs, but they have mentioned it like that, per month as his textile business at Mumbai. Though the respondent denied these contentions, he has not stated as to what is average income per month from the textile business from the date other source. And my lords, kindly turn to peruse, my lords, paragraph number 14. There was an application filed to summon all her income details. Lords, keeping pending of that application, lords, this order, this impugned order came to be passed by the Honorable Trial Court. Paragraph 14 may kindly be seen for a moment. It may be true that the petitioner is qualified as BE in computer science. However, merely because she is qualified, it cannot be said that she is earning. But that is not the case, lords, which is contrary to the record, where the bank account shows that she was drawing salary as on the date of the filing of the petition.
What is the name of the employee shown in that? From which account she is getting?
Soumya V, my lords.
Huh?
Soumya V.
Not her name. Transfer credited to her account from which account?
Soumya V, my lords.
That's the name of the account.
Yes.
Company's account.
Yes, company is crediting her salary to her account, which is in the name of Soumya V.
Who is Soumya V?
The respondent herein.
I am asking, in the statement, what is the name of the company shown?
RZPX, my lords.
Huh?
RZPX. That is Resope, what, my lords, the gateway, payment gateway. RZPX. Kindly see, my lords, RZPX, my lords, private limited. Every month, my lords, it has been.
Agreed with order passed in I number 2, whereby the court had granted maintenance of an amount of rupees 6,000 to the wife. The husband is before this court. Learned counsel appearing for the husband submits till 11/11/2022. Continuously, there is a credit of 76,562 to the account of the wife. And in spite the court, the account, it is submitted that when the wife has stated that she was never working, and when the documents are sought, the documents are also placed to show that she was drawing her salary. The court had went to consider the entries in the account, in her account, and simply it is observed by the court that
Para 14.
It states as, however, it is not clear as to what those credits are. Even if there are any credits, it cannot be said that it is received towards a salary or remuneration. This finding of the court in granting the maintenance to the wife is contrary to law. The burden lies on the wife to place before the court all the statement and also clarify what those entries are. And without seeking a clarification from the wife, and without and the fact that there is income she is getting, the court ought not to have the court had granted maintenance of 6,000. Considering the same, there shall be stay of all further proceedings. Same in this also, and summons by 16.
Ancillary proceedings, my lord, she has obtained the arrest warrant, my lords, which I have placed it, my lords, on.
Already stayed, Mr. Counsel.
Stay. Ancillary proceedings. separate proceedings were initiated.
Once this order is
Yes,
stayed,
great,
it will fall.
great. Why? Because
number
we will
16.
seek clarification. Great.
16, Harish NR, for petitioner.
Appearing for the counsel, the respondent.
Yes. What do you say?
My lord, sir, my submission is this. During the lifetime of the deceased father, an order of maintenance was passed. And there was also an order for recovery. Petition was filed, objection was also filed by him. He was a police officer. And during the pendency of the execution petition, he died. He did not pay. This amount was 10,000 to the child and the mother, which had accrued from time to time. Now, my lord, subsequently he dies, and immediately an application is filed for attachment of his previous
Benefits. Death benefits.
Service benefits, my lords. Service benefits include many components, my lords, not the pension alone, my lords, other benefits. Now, my lord, what is attached is only to the extent of 10 lakhs and odd. And what is his total accrued amount is not stated, one aspect. And second, my lord, minor son and the mother had to survive. The amount is ordered by the honorable courts, my lord, for the sustenance. Now, my lord, one more aspect is the persons who are now coming on record, they say that they're the second wife and children.
Because after divorcing the first wife, he married the second wife.
That's not correct, my lord. Divorce was stayed. And once there is a stay, my lord, he cannot marry.
Where is
And
that?
that's set aside. That's set aside, my lords. They are not produced, we will produce it, my lords. The judgment of the divorce itself has been set aside. Correct? That has been set aside.
So there is no divorce as on.
No divorce. And what they want to say is, what they have pleaded is, my lords, he was not aware of the stay, he married. It is not permissible on Hindu Marriage Act. Hindu Marriage Act itself provides, my lords, second marriage is permissible after the appeal period is over. Before the appeal period, my lords, he should wait till the appeal period. Before the appeal period, appeal is filed. And there are two stipulations, my lord, in the Hindu Marriage Act for the second marriage, my lord, after the divorce, my lords. One, unless the appeal is filed or the appeal period is over. Admittedly, appeal had already been filed. And they don't mention the date of marriage here. They keep it in vacuum. And at any rate, that judgment itself has been set aside. Now, what has been ordered, my lords, they should come out with clean hands. Now, my lord, the wife and the child, my lords, they were entitled to maintenance. Now, the learned son is 17 years. And your lords may kindly see because 14 years, my lords. Now, my lord, now as far as the entitlements, one aspect that they attain finality, entitlement. Now, question is, my lord, whether they can come on record and oppose the dispersal of the amount, my lord, which has accrued in the execution proceedings. My respective submissions be on these counts, my lords, they cannot oppose. Even on equity grounds, my lord, they should say what is the total amount that has accrued, my lords, because they are have the information, my lords. We don't have that information. And the status also, my lords, of the second wife. The moment, my lord, if they are now pleading for a stay, if at all it is stayed, my lord, they will withdraw everything now. And one more aspect is child has to survive. And mother is also dead now. He did not pay to the mother also. Kindly see how unjust he was. He did not even pay to his wife.
Mother is no more.
Mother is also recently. Mother also died. Now the grandmother is taking care of the child, my lords, who has no parents at all. And how can the grandmother sustain the grandmother had to sustain the mother who is no more. Lot of expenses.
Now that stay setting aside, now everything they have lost the significance now because both the parties are not there.
Son's maintenance, my lords.
I'm saying about the mother and father. Their divorce.
One aspect, my lords. Therefore, as on the death, my lords, marriage was subsisting. So, she was a wife. Therefore, my lord, marriage was subsisting. Marriage has never been, my lords, in accordance with, he did not even move for thereafterwards, my lords. Being a police, my lord, he took advantage of everything, harassed the wife, my lords. I am not speaking anything about the departed person, but during his lifetime, he should have paid this. And what made the mother also to lose her life is one thing is, my lord, no economic sustenance at all, and she was suffering with serious illness. This grandmother could not take care of her daughter and also the grandchild. Nothing was paid. This was not for the police man, my lords.
Kindly see RPFC order sheet, my lord. Substantial amount is paid. My lord, this honorable court was pleased to grant interim order of stay.
Don't go into the merits of the RPFC. Your stand is
Please,
that you are the legally wedded wife of
Please.
the deceased so-and-so.
Please.
So from what they say,
Please.
you are not legally wedded wife for the reason, as on the day you married the deceased, the first marriage is subsisting.
1/12/2006 divorce was granted.
Wait, 112?
1/12/2006 divorce was granted. This honorable court was pleased in MFA number 3642 of 2009. The stay was granted on 29/3/2007. 29/3/2007 stay was granted. This was communicated to the deceased respondent on 26/4/2000. 26/4/2007 was marriage with this petitioner.
When is the marriage?
26/4/2007 was the marriage. Subsequent to this marriage,
technically you married after the stay was granted by the court.
but this stay order was not communicated. Notice was not served.
You have to wait.
By the time, my lord,
No,
by the,
appeal time will complete when?
please, my lord, 3 months over. After over of the appeal period, he got married.
And you can't count it from the day the order is passed. You have to count it from the day the order copy is ready.
From the date of
Limitation will start from the day the order copy is ready.
Please, my lord.
When is the order copy ready?
From the date of divorce, my lord,
that is not the limitation. That is not how you will. For example, the order is passed on 1/12/2006.
Please, my lord.
You will file for the order copy. You will apply for the order copy.
I am not urged, that's what.
Not you, whoever it is. When is the order copy ready?
My lord, that order was communicated later on, my lord. However, my lord, even if they consider, if the deceased respondent has admitted the relationship, my lord, even in the maintenance
that is
proceedings,
not by admitting something. What is illegal will not become a legal one.
Legal relationship with, even if it considered, my lord, illegitimate, section 16 of Hindu Marriage Act, my lord, it protects the interest of the child born out of the second marriage. I have, my lord, citation to, my lord, that effect. My lord, there is no discrimination between the children born out of the wide or wideable marriage. They are legally entitled.
We are not
they are
going
recognized.
We are not going into all those aspects.
For a moment, my lord,
the
urgency.
wife, please listen to the court. The wife had filed a petition for maintenance. Wife and the child. Maintenance is granted.
Yes.
That was, then again is that in our RPFC is filed.
Yes.
And during the pendency of the RPFC, he
Stay
died.
is granted.
No,
Subject to deposit of amount. I have deposited the amount.
No, what happened to the order in that order granting maintenance to the first wife has attained finality. Now, to the extent of that, whatever is the amount granted, these are the recovery proceedings.
What?
In the recovery proceedings, they are not asking for the entire amount. Whatever is granted by the court, assuming that you are the legal representative of the deceased, whatever is deduced to him from the estate, it can be recovered from by them.
Like what attached amount is there now, 10,76,000. It is what happens, actual fact, 2023, he fell ill, deceased respondent fell ill. He was bedridden, by the time, he could not comply, continue to pay entire amount as per the order passed in the RPFC. He died, when he was deathbed, he stopped to go to work, Then, even, there is some death benefits also, not extend to the 10,70,000. There is no such amount, below the
whatever is the amount that is granted by the court, which has attained finality, that they are entitled.
They cannot encroach upon my maintenance rate, There are 3 minutes. Kindly see, some facts crucial facts I will point out, Kindly see, there are 3 minors, 3 years old, 3 years, 4 years, 6 years, 3 minors. There is also mother. There is mother.
Forget about your case.
They can't encroach upon the maintenance rate.
Forget about your case. Now, as far as the maintenance that is granted, whether she can recover or not, that you can tell the court first. Don't forget about your client.
In RPFC proceedings, I will substantiate that that is connected to this writ petition as per the order of this honorable court.
What you will argue
I will make
in
out
RPFC,
my case,
What will you argue in RPFC about the quantum?
I will make out the case in the RPFC.
Please understand what case you will make out. She is a wife and the child. Admittedly, she is even assuming that she is a divorced wife. Still the divorced, let us take that the divorce is in and she is a divorced wife. Divorced wife is entitled for maintenance, is it not? Court has granted maintenance. How will it recover now?
Out of death benefits, my lord, all the legal aids are equally entitled. My lord, the respondent cannot encroach upon my maintenance rate. My lord. There are 3 minor children and mother is also there. They have also maintenance rate over that. That they have my lord, section 16. My lord, after they have succeeded that estate. My lord, that becomes estate of the my lord. I have my lord, rulings on that point. My lord, they have
Once it becomes the estate, whatever
that
from
become
a-
estate, my lord.
From an no, the order that is passed is a legally enforceable order. That order, that amount has to be recovered from the estate of the
My lord,
deceased.
that is not correct, my lord, because my lord, once my lord person dies, maintenance right, my lord, extinguish. To the extent of my lord, estate is there. Admittedly there is a estate. He died leaving behind the estate.
No, I'll not pass any order. List is after
My lord,
vacation.
what happened, my lord?
Yes,
One
17.
exigency is in this matter is, my lord, maintenance amount is ordered to be released, my lord. That is, if that portion is stayed, my lord, I will substantiate that case, their case, my lord. Kindly see, my lord, I will point out. Kindly,
No
three
time
lines.
today, Mr. Counsel, for
My lord,
all
only
these
3 lines, my
arguments.
lord. Only
Next
3
matter.
lines, my lord.
Next matter.
Exigency, I am pointing out, my lord, because my lord,
Let-
otherwise the entire amount, if ordered to be released, I will be, my lord, 3 minor children are there, my lord. Their livelihood, my
And
lord,
always you're saying entire amount. What is the amount?
amount, my lord, amounts to 7 lakh something. It is there in the, my lord. It is not, my lord, exactly amount was they claim. It is not, my lord, that amount is not there.
Yourself and confuse the court. I just asked you,
Please.
what are the death benefits of the benefits of the
My lord,
deceased?
around, my lord, 7 lakh and something is there, my lord. Exact amount I will furnish to this honorable court, my lord. They are not entitled to such amount. Even RPFC proceedings, substantial amount is produced. Is it on record, my lord?
According to you, how much amount has to be paid? Was the executing court must have calculated that amount? What is due to him? From that only court said so and so amount he is entitled to recover.
My lord, just I will point out, my lord, if I am permitted, order sheet, my lord, I have paid some amount, my lord, 3,16,000, one amount, 1 lakh amount, some amount is paid. It is all on record, my lord. In the order sheet is recorded. Therefore, my lord, the exigency is that is I am also my only submission is, my lord, for a moment, if order is ordered to, my lord, this death benefits ordered to be released in favor of the respondent, entire petition will be, my lord, vanished.
The order of the court.
The order of the court is, my lord.
Court must have calculated what is the amount.
No, my lord. That is, I have objection on that regard, my lord. For death benefit, they can't claim entire amount. Please, my lord.
There is
But
a-
kindly, one for a moment.
There is also
my lord.
195 days
Not
delay.
able to understand
My
what
lord,
the
kindly,
court.
Was dismissed
for a
once,
moment,
my
lord,
lords.
if this honorable
The
court.
court wants to help you. You're not able to understand that. Why is the court posting this matter to today? You don't come to the crux of the issue, and you argue something. No, you have to tell the court what are the amounts, and you should tell the figure. You don't calculate it. You will say something 3 lakhs, 5 lakhs, 4 lakhs. What is the amount?
Please, my lord.
That what are the death benefits of so and so?
Please, my lord.
That you don't tell. What is the amount due that you do not say to the court?
As per their calculation, it is a 10 lakh 76 per lord.
Ah.
But death benefit is only, my lord, there is existing death benefit is, my lord, around 7 lakh is there is, my lord. Not exactly that.
He has
what
house
they
and other
claim.
assets we are not claiming at present. He is a police officer, he has house and other assets.
This is a
We have
less
not
than-
gone into that.
Like,
And
this
there is a
is
delay of 195 days in filing this petition, my lords.
After
It was
death-
dismissed for default,
default, my lord,
non-prosecution.
because- my lord, I will point out, my lord, dismiss because
We'll
of,
file
my lord,
objection
death
to
of
this
the-
195
my lord,
days.
deceased respondent died. Children's, my lord, wife and children, they are busy with, my lord, taking care of the deceased. They are, my lord, look at the conduct of the respondent, my lord. When the respondent was in deathbed, deceased respondent on deathbed, they filed petition for recovery of amount. My lord, these petitioners take over, my lord, as per even, my lord, the litigation starts from year 2014 itself, my lord. From that, my lord, admittedly, they are with the deceased respondent. That these petitioners are taken care of this, my lord, deceased respondent. My lord, they are also, my lord, in the RPFC proceedings, as in terms of the interim order, my lord, substantial amount is paid.
WP 29081 of 2025. They shall be the court had permitted the respondents to withdraw the death benefits. That's the order.
That's our, my lord.
But death benefits, they are entitled to recover until further orders an amount of rupees 2 lakhs. As far as the remaining amount is concerned, they shall be stayed.
And they shall be kept in the deposit of the court, my lord.
They shall be kept in
My
the
only
Deposit of the
they
court.
shall be kept in the deposit.
My only
Please,
prayer is my entire amount can be kept in. There is no urgency for there to withdraw the amount, madam.
Yes.
Kindly see the age of the
If you
petitioner.
want that order also, I will not grant. Vacate, no order.
No, madam,
List after vacation.
I will withdraw my submissions, madam. Kindly
Yes.
protect the interest of mine.
That's why protecting the interest. That's a balance where it is. You said there are 7.5 lakhs. Now I said only 2 lakhs can be withdrawn. You're protected. Another 5.5 is there, provided if you succeed. Yes.
Number
Much
17.
obliged.
Yes. Yes, next.
Yes. Lord, impugned order is annexure D and it is on page number 39.
39.
Yes, Madhya. Orders are passed in G and W proceedings.
Interim custody of the minor child
Yes.
by spending time on 39 and so from morning 9 a.m. to 8
Yes.
p.m. On picking up the child in any place convenient to both of us, drop back the child.
Yes, Your Lordship, may
Convenient, so
kindly
and so.
come to
So
page
what is
num-
wrong with this order?
Yes, Your Lordship, may kindly come to page number 45, my lord.
Yes. Yes.
Yes, madam. Paragraph number 13. The record reveals that on 23/8/2025, the minor child was conciliated in the chamber. The child did not show inclination in communicating with the petitioner. Since it's taken so, and Your Lordship may kindly see, either in the impugned order or in the order sheet dated 23/8/2025, nothing is mentioned. What was the conciliation? What was the question put to the child?
But whatever
And,
is,
no,
we can't pass any order now without hearing the other side.
Then Your Lordship may kindly permit me to serve the notice on by hand and I may be posted tomorrow. I'll keep the child also present tomorrow.
The petition is permitted to take out hand summons on the counsel appearing for the respondent and file a memo to that effect. If the memo is filed, this is the matter.
Preliminary hearing B group, cell number 18. Cell number 18. Shilpa R for petitioner. Champaraju.
Joint memo is filed.
Let's matter settle. We just received the affidavit yesterday.
Take that.
Issue was with the regarding the
Where are
visitation.
the parties?
The parties are absent, fella. Parties are absent, fellas. The petitioner resides in Hyderabad. That was the difficulty to get the joint affidavit also signed and presented before this honorable court.
Huh?
The petitioner resides in Hyderabad. So that was the difficulty all this while to get the.
I can only, because I can't record all this. It is submitted that I only say they have entered into a compromise. In view of that, they do not want to pursue this matter.
Please.
Both the parties submits that they have entered into a compromise, and both the counsel appearing for both the parties submits that. Give the joint memo to him. And it is submitted that a memo is filed seeking to withdraw the petition as the parties have entered into a compromise. Memo is taken on record and the petition is dismissed as withdrawn. Yes, next.
Cell number 19. Cell number 19. 19 adjourned. Cell number 20. Chandana.
As per the direction of this honorable court, we filed affidavit, my lord. The salary of the respondent is only 36,705.
Earlier, what did you say?
My lord,
Earlier, what did you say? Is it your case that she is working?
as on the date of filing the petition, she was not working. After filing the petition, she started to work.
The wife's income is an amount of rupees 80,000 per month.
That is wrong.
As on today, the respondent shall file an affidavit in regard to what is her income as on today.
I am also producing
Matter
salary.
on 24/9, by the time office objection shall be complied with, or
We have
else an amount of rupees 20,000 shall be paid to the
We have
advocate.
completed the office objection, my lordship. My lordship.
So, now, before the court, what is her stand?
Yes, my lordship.
Uh.
So the interim order, my lordship. What has granted?
Order. Before the court, what is her stand? Whether she is working or not working?
She was working, my lordship.
Did she say so before the trial court?
No, my lordship. One thing happened in the order, my lordship. Page number 25. This order has been passed since first she said in her affidavit in page number 17, before the trial court, filing a,
What is your income?
my lordship,
What is your income?
my lordship, currently my earnings are 80,000, take away.
Let's go to the order. First of all, let's see the order, then we'll
Yes, ma'am.
understand.
Yes, ma'am. Kindly, my lordship. Page number 24, my lordship.
Come to page 26, petitioner wife filed a petition.
Yes, my lordship.
Though petitioner had filed her affidavit for disclosure of assets or liabilities, she has not enclosed any document for compliance of claim F of the enclosure 3 of the above referred case law. She was working in Cognizant Technology before 4/3/2021. She is supposed to produce her previous salary slip and also bank statement. Hence, as the parties had not led their evidence to assess income as well as assess and so and so, on behalf of the respondent is allowed as for a petition is directed to file a bank statement and salary slip. Then
My lordship,
order came to be passed on IA number 2. Whether she has filed later?
my lordship, the order has been passed considering that she is working as a temporary job in the company, my lordship. But right now, where it has been stated in the
No. 27 court talks about certain documents not being filed.
yes, my lordship.
Then advocate for petitioner present memo with documents. Who is petitioner according to the court wife?
My husband, my lordship.
Before the trial court.
Before the trial court is wife, my lordship.
She said her general monthly expenses are rupees 25,000. That's what she wanted. She's earning 36,000. Why she wants maintenance now?
My lord, kindly see the salary certificate which I produced before this one.
Forget about the salary certificate. According to her, her monthly expenses are rupees 25,000 and she wanted 25,000 as maintenance. She is earning 36,000 now. Why does she require maintenance?
My lord, she has to live in accordance with the status of the husband. Husband is receiving 68,000. He is residing in his own house. He is having car, bike, everything. He is leading a luxurious life.
What did you ask? What is the amount you asked as maintenance? Asked my maintenance of 25,000.
Yes.
Saying that these are all my expenses. I want only 25,000. I am not having any other income. Now you place a salary certificate before the court saying that my income is 36,000. So even after 25,000 you spent, you are still left with another 11,000.
Well, along with the statement, I produced certain documents of kindly see. Very recently, my father was met with a serious brain stroke. I borrowed a loan of rupees 12 lakhs.
We are not hearing the subsequent developments. We are looking at what has been stated as on the date of application. What did she say? What are her expenditure? What is her income? When she is getting income, why did she not state it before the court?
My lord, kindly see. A salary certificate also kindly see. She joined at the work on. My lord, kindly see.
My lordship,
21st March 2022, salary certificate shows that she joined at the work.
21st March
Ah.
2022, she got a
22.
job.
She
21st
joined
one
at the work.
21st March 2022.
22.
When is this order passed?
Petition is filed in the year 2011, 21.
No, she joined there and this order is passed. Date of order is when? Date of order is 7/10/2023. So by 7/10, by the time the order is passed, by the time she is leading the evidence, she is already employed,
yes, my lord.
she is already getting salary.
Yes, my lord.
All these facts were not disclosed.
My lord, kindly see the status of the wife. May kindly see. My lord, in an inhuman manner, he
Mr.
throw the
Counsel,
petitioner out of the house.
do not want-
Thereafter, she
I
faced
want-
several ill issues.
I asked you on facts,
Madam,
not on anything.
but all these
I
things are,
said, why did she suppress this fact?
my lord, basic necessity is 25,000, but it is not included her health condition and subsequent payments
If
and
you're not
injuries.
understanding
And all other things
giving,
are not.
and you're going on with the arguments, it would, you
Last
would be,
date of hearing,
you
my
would be
lord.
doing it at the risk of your client.
My
That
last
I'm
date of
making
hearing,
very
my lord.
clear.
My lordship, one more submission, my lordship.
Appeals court.
Yes,
Last date of hearing, I put judgment of the appeals court, 2021 to Supreme Court, case number 324, wherein it is stated that even though the wife is earning, she has to maintain the status of the husband. Now, my lord, his husband is residing in his own house. Wife is residing in a rental house. My lord, he is getting, as per his own statement, he is getting monthly salary of rupees 68,000, whereas the lady is getting only 36,000. The first date of hearing, they made an incorrect statement that I am getting 80,000 rupees. Of course, my lord, my basic need is 25,000. Apart from that, I have to incur the expenditure of medical expenditure of my father as well as me, because
yes.
Because my lord, medical expenditure of me, my father, my lord, and along with my statement, I produced the entire medical report of my father. My lord, so kindly see, on 26 to
No,
2025.
I'll hear you and all other arguments also. So according to you, she has employment from which date?
20.
It
21
is
March
mentioned in the
22.
salary certificate. Also kindly see, 22,
21 March 22.
21 March 2022.
21st March 2022 and drawing salary of 36,000.
This salary is a recent August salary. By that time, that was not there. Latest salary slip I produced before this honorable court.
I'm asking from when she's working.
Same date, my lord.
My lord, she started to work in the year 2022 as stated.
22.
Yes.
Please.
In the
wait.
initial, it was
Please
a
wait. So
temporary
was
basis
was
earlier.
was this aspect brought to the notice of the court? It's a simple question.
No.
I'm trying to ask you.
No, my lord.
You're not answering to that. You have not brought to the notice of the court that you are earning.
My lord, earlier it was a temporary job. Temporary job. Later it became permanent. My lord, temporary job is anytime she may be removed, my lord. His work is not up to mark. She will be removed at any point of time. Though she joined in the 2002, her service has become regular after.
Reading Rajneesh versus Neha, you should also read what Rajneesh versus Neha says about this kind of a conduct from the wife who has suppressed facts before the court. What should follow? Perjury proceedings should follow. If in the same lines you want to argue, I'll direct the court to initiate perjury proceedings against the wife for making these kind of misrepresentation before the
Now
court.
I am not disputing, my lord. Now I am getting salary of
It is not about
36,000.
disputing. You have to state why did you not state? It's a question.
My lord, status of the husband is more, my lord.
Yes, I'll
Status
record
of the
that.
husband,
Yes,
he is
I will
getting more
record.
salary and more payment.
That I'll record.
If such is the case, my lord, he's a poor lady, my lord. If such action would be taken, my lord, she will be under trouble. Or again, she lost everything. Statement is concerned, my lord. Earlier it was a temporary basis because then it was not mentioned. Because there is always
Simple. You're now, that's what I said. Whatever arguments you're advancing, that would be at the risk of your client you're advancing. What you have to say, that she has not stated the facts, that should be one submission from your side.
Please, madam.
Instead of that, you say the financial capacity, that should be, we know law. All of us know law.
Due to oversight mistake or some other thing.
That should have
it may
been
not
your
be
first
happen.
submission, not oversight. She didn't want to tell it to the court, she didn't say. When you can read Rajneesh versus Neha, one paragraph, you can also read the other paragraph, which says what are the consequences.
I pray for some
Come,
time.
I'll dismiss this, I'll allow their petition. Agreed with orders passed in I number 2. In criminal miscellaneous number 421 of
My lord, kindly see,
2021.
my lord, earlier she filed a divorce petition and she tampered the PF account of the lady.
Where the,
No, my lord, she borrowed loan of
Matter of
12
fact,
lakhs.
where the husband,
In spite of a inhuman situation, my lord,
Directed
if the
to court.
husband is acting in such a manner, my lord, I hope sincerely admit that there is no justification to the poor lady.
the wife is
Although
entitled.
intermediate order is only 10,000. He is getting an income of 68,000. Apart from that, tuition fees and own house, rental income, all other things are
There
there.
are two options.
Merely committing some mistake by the wife,
Counsel,
my lord,
there
is
are two
not.
options, I'm telling you. One, you want the court to record entire thing, your submissions, their submissions, material on record and pass an order is one. Second, without recording all these things, dismissing this petition, by way of both, I'm going to dismiss it. What you want, you please tell the court, I'll do it that way. Number one, without recording all this suppression, I'll pass an order. Number two, by recording all that, I'll pass an order. What you want?
My lord, regarding suppression is concerned, my lord. If you lordship come to the conclusion that there is some misrepresentation, I am sorry to that extent. Merely to that ground, my lord, she cannot be
That will
dissented
be the
for
only
maintenance.
ground. That's the only ground. That's the law.
Right.
Yes. Agreed with the word passed in order passed in I number 2 in criminal miscellaneous number 421 of 2021, dated 7/10/2023, whereby the court had granted maintenance of an amount of rupees 10,000 per month.
May make one submission. Petition is filed in the year 2021. IA was also filed by the same time. By the same time. And my lord, the interim order is passed in the year
You will pay the
2023.
maintenance from 2021 till the date you got the employment.
Job, there is no job in the year 2021.
That's
She
what-
joined only in the year 2022.
What I'm saying, from 2021 till 21/3/2022, you will pay the maintenance.
We submitted that. We are working in temporarily. There is no suppression, my lord. We orally submitted that.
What, how can you say orally? When you have filed your statement
It is
of
also mentioned in
liabilities,
order. Lordship, kindly
where
see.
is the question of orally submitting?
My lord, kindly see the order passed by the, one more document. Lordship, kindly see. Here is the petition, my lord. One more document, Lordship, kindly see. My lord, page number 23, Lordship, kindly come to. Some of the order sheet. Page number 23, my lord.
Yes.
Here on orders on IA, here number 93 is concerned. The submission also kindly see, the petitioner is working as a finance process enablement associate in Ancestor Solution Private Limited since March 2022.
That's what.
We stated that. Until date, earning 34,734. We submitted
Where is
per
that?
month. But the, my lord?
Application under 91 CPC filed on behalf of the respondent.
Yes.
Petitioner and respondent have naturally agreed to so and so. Petitioner, hiding the true facts, has filed false case against the respondent with the leave for maintenance. He's working as finance process, that is his case.
That's a matter of trial.
March 2022 till date and earning, that is, he has already filed a petition for perjury. That, it is not your statement, that is his statement. Court said it will be, it will deal with it in a later point of time.
Kindly.
But we have now
Agreed,
suppressed. By the time she was only temporary employee.
Still
Because
she's
of that
working the
reason we have
same
not
job.
stated, my
Agreed
only
with
that
orders
much.
passed on
She's
I
not
number
a.
2 in the-
My lord,
so
I
and
pray
so.
for some time, my lord. I will clarify the.
Kindly, ma'am.
Huh?
I pray for some time.
Why?
I have to produce some document in this
What documents?
regarding her joining of the service and other
You
things.
said so, 21/3/2022.
If any observation made, my lord, it will definitely have affect her interest because
Huh?
she's already deserted at the hands of the respondent. Because my lord, she's already filed divorce petition, and later my lord, she joined her hands with this girlfriend and tampered the PF account of the petitioner. Then we question before this honorable court. All these things are there, my lord.
Yes.
And the status of the husband is better than the status of the wife. And such a circumstance, if any observation is made, my lord, it would affect her interest. That's what I want to get some further clarification from her.
There is no further time for this. I can only look at the order that is passed. No other documents are required.
My lord, if it is main petition itself will go, my lord.
It has to go. Petition is not for
That's the
this
reason.
kind of
I pray for some
litigants
time to get.
who come to the court by suppression and misrepresentation of facts. This is matter after vacation as part
My,
of.
my lordship, my lordship, the affidavit what they have submitted today, they have tampered it, my lordship. Kindly, my lordship. The page number, my
I
lordship.
look at it as part heard after vacation.
Kindly, my lordship.
After
Kindly,
vacation, this is.
my lordship, kindly, my lordship. The time which has given to them, again they tamper, again they fabricate the evidence whatsoever you require, my lordship. My kindly check the affidavit.
I am not passing order. Why should I look at
No,
all
my
that
lordship,
now?
whatever the time has given in the last.
Matter, no part heard. This is matter after vacation. Yes, next.
My lordship, kindly.
21.
21.
Cell number 21. NN Raj arrest for
There is a
petitioner.
connected appeal
This
pending
case,
before
madam.
this court, and earlier that appeal has been connected with this appeal, my lordship.
Where is the appeal? This is a writ petition.
That is a writ petition 12334. That has been listed on 22nd of this month.
List along with this after vacation.
No, that is the separate proceedings, my lord. I have sought for quashing of the order passed by the trial court. Now, in order to protract the proceedings, my lord, she has filed one more writ petition for enhancement, my lord.
But it has both of them have to be heard at a time. How can we, without hearing her, how can we pass orders in this case after vacation? 22.
Cell number 22. Chandana Tarika K for petitioner. Sachin DS.
Yes, next. Yes.
Cell number 23.
For the petitioner, on the last occasion, I had drawn the attention of this honorable court to page number 61 of my petition, stating that the affidavit of assets and liabilities that was filed by them was not in compliance with the Rajneesh versus Neha. I had filed objections before the trial court. The bank statements that were given were without the deposits column and the
What is the
balance
impugned
column.
order?
Ladyship, the impugned order is one challenging an order of maintenance. Both of us are challenging an order of maintenance,
Where is
granting
that?
rupees 20,000 per month. Your ladyship will find the impugned order at page 73 of my petition, your ladyship. The reasoning start is at page 77, paragraph 9, your ladyship.
Yes.
The affidavit of assets and liabilities filed by the petitioner number 1 discloses that she is working as a primary grade facilitator and drawing net salary of rupees 18,000 per month. She has to pay school fees, tuition fees, school van charges, and her monthly expenses are about rupees 50,500. According to petitioner number 1, the respondent is having a share in ancestral property, so and so. She has further contended the respondent has sold his ancestral property for so and so. The affidavit of assets and liabilities filed by the respondent shows that he has to maintain his aged mother. He has been paying EMI of rupees 48,000 per month and working as senior project manager in Accenture with net salary of rupees 2,02,488 per month. The pay slip shows so and so is the salary, your ladyship. As I've already stated earlier, the petitioner number 1 is taking care of petitioner number 2. It is true that the petitioners are residing in the house purchased in the joint name. The petitioner number 1 has submitted that her net salary is rupees 18,000 per month. Compared to the petitioner number 1, the respondent is earning more income and he's having capacity to pay reasonable maintenance to the petitioners. It appears that the petitioner number 2 is aged 7 or 8 years and studying in 2nd or 3rd standard. It is the responsibility of the respondent to provide maintenance to the petitioners. Taking into consideration of the available materials on record, the respondent is capable to pay interim maintenance of rupees 20,000 per month altogether to both the petitioners, that is mother and daughter. After the admitted income being 2,02,000, your ladyship, bonus has not been disclosed. Bank statements do not disclose the balance column at all.
What do you say?
Your lordship, if you are, this is the salary.
No dispute about the fact that your income is 2 lakh.
That I have produced the salary slips before the trial court, and accordingly the trial court has looked into the salary slips, and that I admit. In respect to the bank statements, whatever I filed, that's a subsequent bank statement where my salary is not getting credited, and it has skipped. The balance column has skipped. That wasn't my intention. Like basically, I've transferred. I had inquired with the client. In terms of like what has happened, and the balance column is skipped, and that is the memo that they have filed at page number 61, saying that the balance column is not getting reflected. That's the only thing. But otherwise, I have another bank statement that I have filed that is complete. That wasn't my intention,
So
and
when
also.
your salary is 2 lakhs, why the maintenance is 20,000?
And your lordship, if you can look into the reasoning again for a moment. And also the objection, statement of objections. If you, first let us go with the page number 33, the application, what they have filed before the trial court. Page number 33, Annexure C, Your Lordship. For the reasons stated in the accompanying affidavit, it is humbly prayed that Honorable Court please to direct respondent to pay a sum of 85,000 per month towards the interim maintenance of the petitioners, and also, this is the second prayer in the same application, also direct the respondent to continue to pay the EMI of 49,000. And the EMI is being paid towards the house she resides at this point of time, where she was made as a co-owner, but the entire property from the beginning is being paid by me, and also she ousts me from the property and she takes a restraint order. I was before this particular on a writ petition, where this honorable court had not interfered in that particular order, but directed the opposite party to give the articles which was lying in this particular house, and they haven't returned those articles. I am on contempt before the revision bench, which is on that also. And now I have stated in the objection, page number 28. Page number 28. This is my objection, Your Lordship. Page number 28, the expenses what I incur. And this same thing has been elucidated before the trial court in the assets and liabilities also.
How much is coming to?
It is 1.73 lakh on the top of the thing, including the EMI where she is residing at this point in time. And these are the expenses that I am paying. And I'm left out with a sum of 25,000. And for which I have also filed a cross petition to reduce it. In respect to the petitioner herein, she is earning a job, she also admits. Now it is around 30,000 rupees what she is getting.
I apologize.
And before the trial courts, they admit that that she is getting around 18,000. But now she is getting around 30,000.
My salary is 20,000. I'll file an updated salary slip before this court. 20,000 as of this day. My request is, without knowledge, such submissions needn't be made. September 22, Your Lordship.
2,02,000 is the total earning which the trial court has looked into the salary slip and considered my expenses and everything. And again, I am left out with only 25,000, for which the trial court has granted 20,000 for both the petitioners. That is the petitioner number.
So here, certain amounts you have stated are not monthly, they are yearly. Look at it.
Pardon, Your Lordship.
Yearly property tax. Then the Sukanya Samriddhi, that is also yearly.
That is 5,000 every month I have been paying,
Then
60,000.
let's see. Then Tata AIA life insurance policy, 25,500.
That is yearly.
That's yearly.
That's yearly.
So that 25,000 is here.
Pardon, Your Lordship.
That is also calculated in 1.73.
25,000 insurance
Has to be
policy.
deducted from this. It is a yearly one.
That will have to inquire whether he is paying it monthly or
It will be, insurance won't be monthly, it would be yearly.
that
So
I'll have to.
25,000. So that's what, that is like, then even SIP for mutual fund. Yes, please come.
And if Your Lordship can look into page number for a moment.
What is your income?
18,000, 18 at the time of filing, 20,000 now, Your Ladyship.
20,000. What are your expenses? Let's see.
And they haven't filed that.
Lady, I have filed everything. Your Ladyship will see my expenses at page number 36. Expenses for my daughter and me, Your Ladyship. Grocery and provisions, rupees
3,
15,000.
medical 4, domestic 8, transportation 5, phone, internet 3, building maintenance 4,000, contribution to in the first petition Sukanya Samriddhi scheme for the child. What is he is also contributing.
He's contributing, I am contributing as well.
She is not, Your Lordship. She is not contributing towards Sukanya Samriddhi. It is only me. 5,000 is what I'm contributing. She's
Is
been
it
claiming
correct?
that.
Show some document in this regard.
Very well, I will produce.
Yes.
Apart from this, your ladyship, if the
No.
petition is filed in September 22.
No, we will decide it.
And
Only thing
moreover,
is-
for a moment,
I'll pass over, get instructions on that.
I'll get instructions on
18,000
this.
whether she's paying or not.
Please,
If
very
she's paying, let her show.
Your Lordship, you may kindly have it on Friday or something, Your Lordship.
Because I'm already,
Because the one thing, page number 71 might kindly be looked into. Your Lordship has passed this particular order. Even they are on contempt. They don't give articles to me.
that will not have a bearing on this case. Yes, 69th, about that, find out.
Please,
Pass
please,
on. Yes, next.
Cell number 24 again, 25. Cell number
Your Lordship
25.
can have it on tomorrow at least, Your Lordship. Because like I have inconvenience, I'll have to travel outside.
Tomorrow. Because there are so many matters. It's difficult for the court to accommodate. Advocates have to understand that also.
I understand, Your Lordship.
Yes,
I had
tomorrow,
this-
tomorrow.
25, serial number 25, Rupesh Kumar S. for
For the
petitioner.
petitioner, the matter is already
Proceed.
settled. The matter is already settled between the parties. Kindly have, immediately after vacation for reporting.
Fine, you
Because
can say that
one matter was transferred from Madikeri to Mysore, my lord.
Hmm.
Then you have the CP petition filed by the respondent. So once the matter is transferred from Madikeri to Mysore.
submitted that the matter is already settled between the parties. This is matter after vacation. 26.
Cell number 26. Fatima SK for petitioner.
There is a report of the
26,
councillor.
report.
To our
IPO for the respondent.
What she says is like knowingly, unknowingly, the boy knows so many things, and it's duty of the mother to see that is not exposed to these kind of things and prepare him well for the visitation.
Understand, my lords, the report was not directed to be shared, so I'm not aware what is
Both the registry is directed to issue a copy of the report to both the councils. This is matter after vacation.
Great.
Number 27. MD Raghunath for petitioner, K. Tejas.
There's a direction by the Honorable Court
Respondent, my lord,
for
the
the
matter may,
respondent to furnish certain documents that they comply with the order.
my lord, may kindly be taken up after vacation, my lord. We need some
A
time.
date may be fixed, my lord, if that is the case.
After vacation, give a date, maybe on 29th October. Yes, next.
2310.
Please, my lords, much obliged.
Obliged.
Number 27. 27, 23.
27 is
Yeah.
this,
Cell number 28.
no
Cell number-
representation after vacation.
Cell number 29. 29 urgent. Cell number 30 final hearing.
No
Ravi Shankar
representation
CR.
after vacation
Yes,
in the month of, list in the month of December. Yes, next.
Cell number, list number 2. For orders matter, cell number 1.
My lord, in this for the petitioner, I seek permission to convert into a writ petition, my lord.
The writ petition is filed. The RPFC is filed. Questioning, where is impugned order? Questioning an IA. Questioning the order passed in I number 2. Internal miscellaneous number 2022. Dated 31st January 2024. The office has raised an objection with regard to maintainability. Office objection is upheld and the petitioner is permitted to convert this RPFC into a writ petition within a period of
2
1
weeks, my
week,
lord.
huh?
Weeks, my lord. In a week.
Within a period of 2 weeks from the date of the copy of within 2 weeks from today, and the registry shall return all the documents, all the papers to the respondent for statistical purposes, to the petitioner for statistical purposes.
Disposed.
RPFC is disposed of.
Please. Number 2. Hearing on interlocutory application.
Well, I appear for petitioner, my lord. My lord, this non-prosecution, my lord. I filed a.
You are representing whom?
I appear for petitioner, my lord.
Yes, password.
I'm for the respondent.
Yes.
Wife and daughter, my lord.
255 days in recalling the application. Why? Yes, Mr. Kumar.
My lord, there is, my lord, the last date of hearing, my lord, it was posted for order non-compliance objection, my lord. Very, my lord, by oversight, my lord, my colleague has not completed the office objection, my lord. In the meantime, my lord, last date of hearing also, this court directed me to complete the office objection. That has been completed, my lord.
So they have not provided me the annexures, my lord.
Have you served the copy on her?
Well, it was served, my lord.
She
Not the
says
annexures.
annexures are not served.
I will serve, my lord.
When you're not showing any interest in prosecuting an appeal of 2020, petition of 2020, why should we grant you repeated times? You don't serve papers
No,
on
my
the
lord.
other side. You don't serve the office of
It was served, my lord. My lord, it was served, my lord.
This is matter after vacation. By the time, if the memo is not served, the entire papers are not served on the respondent, I number 1 of 25 will not be considered by this court. Yes.
Cell number 3. Ramesh P. Kulkarni.
For the respondent, my lords.
S.V. Prakash for
On the
respondent.
last date, your lordship directed me to get instruction regarding the house which was in our joint name is let out for somebody or not. It is not a rentable stage, my lords. It is not let out. She is not earning, my lords.
Ground floor and first floor, one portion they are occupying. It is a RCC building, my lord. I will have to file additional affidavit.
After vacation. Yes, next floor.
Cell number 4.
Please.
Sunil S. Narayan.
274 days delay in filing the petition.
We will consider, and only if I feel the reasons for convincing, Then only we'll entertain RPFC, otherwise no. Where is the IA?
Yes.
It's by the wife or the husband.
Yes, page number 34.
Subbaya alias Satish, husband.
Husband's.
Most,
Husband's petitions.
54, yes. Please read.
I submitted 27 to 24.
Because the order was dated 27 to 2024.
Yes, Your Lordship. My
10,000.
counsel informed me that Principal Dismissal Court has
On
pronounced
27 to my counsel informed me.
come
Has
to meet me, but
pronounced the
due to my work pressure,
order and
I
asked
could
me
not
to
meet.
come and meet you.
The petitioner here is a working as a in the forest department. Met my counsel and applied for certificate of the order, and my counsel asked me to approach.
Can any court will condone the delay on this reason?
Not only this, he was posted. He was posted.
Where did he say all that?
Counsel applied.
I think for whatever it is, it won't take 274 days delay for filing this petition. No, the warrant has, the EP must have been filed, and now warrants must have been are in the process. Now he has come to the court.
He's paying the from his salary per month 30,000 has been he's been
The
deducting.
issue notice will not interfere.
Like it is, they have appeared.
Where is Nirmala K?
They have appeared. Last date they took time to file objections.
Yes, for objections after vacation.
Interim orders there.
Show that. Who granted interim order? This court?
Not this court only granted. On
I have granted.
On 9th.
I have not granted interim order.
9th
Because I am
April.
wondering, I will not grant interim order in this kind of cases.
The 9th April to 24 interim order has
But
been
all I
granted.
granted is extended to the next date of hearing.
Cell number 5 adjourned. Cell number 6.
Notice to the respondent.
Appearing for the petitioner, my lords. My
Notice.
lords, matter is pending in an MFA between the same parties before the division bench. And the counsel by name B.V. Vidyulata has entered appearance. So notice may be issued to the
The petition is permitted to take out notice on the counsel appearing for the respondent in MFA number.
MFA number 8589 of 2024, my lords.
Yes. After vacation.
Much
Yes, next.
Cell number 5 admission. Cell number 7. Cell number 7.
Respondent.
No representation.
They have
On
paid
behalf-
the amount, but
No representation. This is matter for dismissal tomorrow. Counsel for the respondent is present. Yes, eight.
Cell number 8.
date, please.
Tomorrow.
Please.
Yes.
Settle the matter before the mediation report.
For the respondent, madam.
Petitioner also present before the court.
Give the report. Where is the report? This court. Please come. This court has referred the matter to the mediation on 31/7/2025. Now the report is placed before the court whereby both the parties have agreed the husband has agreed to pay a sum of rupees 15 lakhs to the wife as full and final settlement. It is agreed that a sum of rupees 7,50,000 will be paid at the time of filing of the
Petition.
mutual consent divorce petition, and a balance of 7,50,000 at the time of recording the settlement. And also the husband will take a life insurance policy in the name of the wife. The husband has already taken a policy in the name of the wife, having policy number 36554963. What is that? And he has not paid the premium for the past 6 years.
Please.
And he has not, no, the respondent husband had taken a life insurance policy in the name of the wife, and he has not paid the premium for the past 6 years. He has no objection for the wife to revive the policy by paying the premium due and continue to pay the subsequent premiums. With this arrangement, it is submitted that as the dispute is fully settled, they'll appear before the court by filing a 13B petition.
Please.
In that view of the matter, recording the settlement as per the terms in the memorandum of settlement before the mediation center, which is placed before the court. The RPFC is disposed of. The settlement shall be part and parcel of this order.
Yes.
Published.
Published.
Yes, next.
Cell number 9.
The parties have settled the matter.
It is?
Parties have settled the
No.
matter.
A memo is filed stating that the parties have already settled the matter, and so memo is filed. Memo is taken on record, and the writ petition is dismissed as dismissed. No further orders requires to be passed, as the parties have already settled the matter, and accordingly dismissed as withdrawn. Write it as withdrawn. Give it to her. Withdrawn
Cell
only.
number 10.
Oh.
Cell number 10.
Hey, for the respondent,
Gowda.
please, ma'am.
You are for the respondent.
Please.
Any interim order in this?
Yes, ma'am.
Complied with?
No, my lord.
Not
The
complied?
stay has been granted, my lord. No,
My lord,
3,000 was
for the
granted by
petitioner,
the
my
trial court.
Huh?
3,000 was granted by the trial court. That has been stayed by this honorable court.
My lord,
Yes,
I am
Mr.
the petitioner, my lord.
Where are you?
Kindly pass over, my lord.
Yes, pass over.
Lord, in that event, not kindly have it after vacation,
After
because
vacation.
2:30
Yes,
I have
ma'am.
one matter before
Yes,
the.
yes, yes.
Cell number
11.
11.
My lord, interim order has to be extended, my lord.
Interim order only granted is extended. Yes.
But appear for petitioner, my lord. Yesterday, your lordship has directed me to file a memo of calculation, my lord. Yes, sir.
Yes.
So the respondent is served as underrepresented in this case.
What is this petition? I'm not able to remember why this.
But the mother is filed, my lord, a petition.
Huh? Where did I ask you to file this? When was the order? When was the order? When was the order directing you to pay this, to file this?
No, yesterday matter is posted, my lord. Your lordship have orally directed me to file a memo of calculation. That's why, my lord,
Yes.
filed a memo.
Let's see. What is the order?
But the order passed by the trial court, my lord, in page number 14. Lord, in criminal miss number, miss number 404 of 2010. Lord, the last page, your lordship
The
may kindly
respondent
come.
is directed to pay some more rupees 12,000 per month to the
12,000.
petitioner as maintenance.
Lord, in the year,
Time.
Lord, in the year 2010, my lord, she has filed a petition claiming maintenance. Lord, the trial court awarded, my lord, 3,000 rupees per month. My lord, against which, my lord, the petitioner, my lord, filed a petition before this court, my lord, dispose of the petition, my lord, remand back to the trial court for give an opportunity both the parties, my lord, produce the additional evidence and the necessary documents. After consideration of remand, my lord, the honorable trial court, my lord, awarded 12,000 rupees per month. My lord, as per the, my lord, arrears of maintenance, my lord, 3,000 rupees, my lord, 11 years, 3 months, my lord, 4,05,000. My lord, your lordship has calculated orally directed me to at the rate of 6,000. You calculate the amount, my lord, 14 months, my lord, 84,000. My lord, total come to, my lord, 4,89,000. My lord, is already paid before the trial court 1,25,000. Remaining amount, my lord, 3,64,000 balance amount is there, my lord, before the trial court. My lord, I ready to pay that amount, my lord, in the installment before the trial court. Blood, she's filed a, my lord, domestic violence petition in the year 2014. Blood, she in the said petition, my lord, she is categorically admitted that,
So
my
you
lord,
have to pay 3,64,000 more.
as on today, the balance amount is there.
So how are you, when are you going to pay?
Lord, in that amount, my lord, I'll continue to pay. Your lordship has directed me to, my lord, continues the pay, my lord, as per your direction, my lord, ready to pay future. My lord, 3,64,000 amount is concerned, my lord, ready to pay before the trial court, my lord, in the installment, my lord.
That's what you have to tell when, where and how.
Well, monthly installment, whenever the trial court, before my date is given before.
Whenever there has to be, we have to pass a definite order. How many installments you want?
But I am also, my lord, doing small businesses. I have wife and children, my lord. Requested me to, my lord, at least, my lord, 6 or 7 installment, my lord. That amount, my lord, remaining balance amount, my lord.
So every 6 installments would come to, each installment will come to 60,666.
Yes.
One installment is 60,000. Into 6 installments would be the amount. What is due?
What is the due amount? Yes.
3,60,000 and all.
Please.
So when are you going to pay? How? Now today is what? 24th.
24.
This is 24th of September.
Yes.
Then every month will say every 24th September. Then again 24th October, first
Please.
installment. 25th October, second installment. 25th November. 25th December. 25th January. 25th February. By February, you will complete the arrears.
May request, my lord, one humble request, my lord, make it 50,000 every installment, my lord. Make it 50,000. Seven installment.
Another 64. So
Yes.
7 installments. Last installment would
40.
be 64,000. No?
Yes, my lord.
Please come. Agreed with the order passed in. Criminal miscellaneous number 404 of 2020, whereby the court had granted maintenance of an amount of rupees 12,000 per month. The husband is before this court.
Allah, maga. Lord, son, my lord.
Son.
Son.
Agreed with the maintenance that is awarded to the son of an amount of rupees 12,000. The husband is before this court. It is submitted that earlier the wife had filed a petition seeking maintenance of 3,000, and he has been paying the said maintenance till this order is passed. It is stated that by virtue of this, by way of this order, an amount of rupees 12,000 is awarded. What is your salary?
Lord, I am doing small business. I am
He is
not an
doing a
employee.
small business and there is no definite income, and it is difficult for him to pay the amount. It is submitted that the court may consider the difficulties of the father and may pass appropriate orders. Though notice is served, none appears for the respondent. Next para, having heard the and grounds for the petitioner, peruse the material on record. On the last hearing, the matter came up. This court had directed the petitioner to place before this court what are the arrears. And from earlier order is 12/6/2014, and the latest order is on 27/7/2020.
Yes, my lord. 27/7/2024.
But it should be from the date of the petition. This, when did she file the petition for
But in the year
10,000?
2010, my lord. But
For this latest one, earlier
Yes.
she sought for 3,000.
yes,
When did she seek for this enhancement?
enhancement 50,000 rupees, my lord. After remand back the matter, my lord, she is seeking 15,000 rupees.
Further, there should be a date. From that date only this will be operative, not from the date of order.
But
This 6,000 will be operative from the date of her IA seeking maintenance.
Lord, this order was passed on main petition, not IA.
That's what, when is the main petition filed seeking maintenance of 10,000 or 15,000.
Let us verify, they tell
Please,
exact
please
date.
verify.
Please.
Pass over.
Cell number 12, Devendra N for petitioner.
Now you understood. At 3,000 till she files an application for enhancement. Calculate 3,000 from the date of that petition till this petition. From this petition, it is 12,000. That is now, I have asked you to calculate at 6,000. Yes.
I request you kindly have it after vacation.
Which one?
12, serial number 12.
Happy for responding.
Yes, after vacation.
Public.
Yes.
Number 13, urgent. Cell number 14.
Lord, I have people for the response.
Oh.
Petitioner.
Where is the counsel?
Lord, last time, kindly see your lordship's honor, Lord, order, because they are not representing as per this, Lord, order of this court, Lord, I have served the copy on the counsel who represent before the trial court. Despite that, Lord, they have not appeared.
Yes.
But its only case is, Lord, the
Come
earlier.
to the impugned order first.
No. Impugned order, my Lord, kindly, portion of the order, my Lord, page number 29, my Lord. The petition filed by the, under section 25 of the CRPC by the petitioner against the respondent is allowed in part. The respondent is ordered to be pay maintenance of rupees 4,000 to the petitioner number 1 and 2,000 to the petitioner number 2 per month as per the order of IA number 2 till the.
What is your income?
Lord, he is not working, Lord. He is an agriculturist in Lord, where in Tumkur, remote village. No documentary evidence, my Lord, has been placed.
4,000 to petitioner number 1. Who is petitioner number 1?
Wife, my Lord.
Then again, respondent is ordered to pay maintenance of 6,000.
That is, Lord, the first order is, my Lord, because interim maintenance was awarded in the IA which has been filed. So that is not paid because that is also to be paid now. And subsequently, the main order is on para 2 number. The respondent ordered to pay maintenance.
Final order is 6,000.
6,000, Lord, and 3,000.
9,000. Then?
The petitioner and month from date of this order and her lifetime till she remains and pay maintenance 3,000 to the petition number 2, that is a child. Lord, here the petitioner kindly see, Lord, the only the para 20 early, because she's not willing to reside in the village. She wanted to reside in the Bangalore. That is the only contention where they are separated. Now, because he doesn't have any, because only his old age father is there. No mother, nothing.
You filed your statement of assets and liabilities before the court?
Before the trial court, which has been filed.
What did you say? What is your income?
That may be, my Lord, it is not filed before the trial court. Nobody has filed. Even other side is also not filed, my Lord.
So how should we assume that you don't have income?
That is what, my Lord, now I have taken. That is what it is come out in the, my Lord, because
Even
they
why
themselves.
did you not file? File before this court.
Yes.
This is matter after vacation. The petition shall file a statement of assets and liabilities as per the judgment of the apex court in Rashish versus Neha.
Great.
Yes, next.
Petition number 3, cell number 1.
After lunch, call this after lunch.
Yes.
Again, next one.
Cell number 2.
This also after. 3.
Cell number 3, P. Mahadev Swami.
After. Yes.
Cell number 4,
I have for second is.
Kavita HC, await.
It's okay. TCR is required in this.
Yes.
List this matter after TCR is received. Oh, I think she has moved.
Yes.
Memo is moved.
Memo it means.
Moved, I think.
Yeah.
Password? Password.
I am ready.
Password. I think she wants this matter to be heard. That's why memo is moved. Yes, 5.
Cell number 5, Nanjunda Swami PL, acceptance of process memo filed at after
the process to be accepted and notice to be sent to the respondent.
Yes.
Yes.
Cell number 6. Cell number 6.
After. Where is he?
A.N. Krishna Swami.
We'll have it. We'll have it at 2:30. Yes.
Cell
I think
number
they are not. None of them are there.
ನಮ್ದಿಲ್ಲ 2:30
ಸರ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗಿರೋದು
Court officer? Court officer? Madam. Court officer? Court officer?
ಇನ್ನೂ ರೀಚ್ ಆಗಲಿಲ್ಲ ಸರ್.
ಏನಂತೆ ರೆಡಿ ಅಂತ
ರೆಡಿ ಇರಲ್ವಾ ನೀವು?
ಎಲ್ಲಿವರೆಗೂ ಬಂದ್ರಂತೆ ಕೇಳಿ.
ಏನಂದ್ರಿ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳ್ತಾ ಇದ್ರು ಅದೇ ಮ್ಯಾಟರ್ನೇ. ಅದು ಇನ್ನೊಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿದ್ರು, ಇನ್ನೊಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಿದ್ರು. ಅದಕ್ಕೆ ಲಿಸ್ಟ್ 3 ತಗೊಂಡ್ಬಿಟ್ರು ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ಅವರು ರೆಡಿ ಇದ್ದಾರೆ ಸರ್.
ಸರಿ ಮುಗಿಸೋಣ.
ನೀವು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅಂತ ಇದ್ರಲ್ಲ, ಕೇಳಿಸ್ಕೊಂತ ಇದ್ದಾರೆ.
ತಗೊಳ್ಳಿ ನಮ್ಮ ಇದು.
Court officer. Court officer.
Is the matter. Hello? Hello? Hello, court officer. Court officer. Court officer. Sir.
Court officer. Sir, court officer.
ಹೇಳಿ ಮೇಡಮ್.
ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಏನಾಯ್ತು ಮೇಡಮ್?
5 ಅಲ್ಲಿ ಪ್ರಾಸೆಸ್ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂತ ಆಗಿದೆ.
ಆಗಿದೆ. ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಇನ್ನೆರಡು ಡೇಟ್ ಗಿವನ್ ಮಾಡ್ತಾ ಇದೀನಿ. RPFC ಒಂದೈತೆ, ಸೈನ್ ಮಾಡಿಸ್ಬಿಡ್ತೀನಿ ಬಂದ ತಕ್ಷಣ. RPFC 85/22. WP ಬರಿ ಫಸ್ಟ್. ಬೇಡ ರಿಪೀಟ್ ಕೊಡ್ತಾನಂತಿದ್ದು. ಅಲ್ಲ, ಒಂದು RPFC ಒಂದು ಬರೀತೀನಿ. 85/22 ಒಂದು ಬರ್ತೀನಿ. ಅಲ್ಲೇ ಇದೆ ನೋಡು, ಬರ್ದವಳೆ ಸಣ್ಣ ಬುಕ್ಕಲ್ಲಿ. ಪಾಸ್ ಓವರ್ ಆಯ್ತಿಲ್ಲ ಅದು. ಒಂದು ನಿಮಿಷ. ಅದು ಏನಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ? ನಿಮ್ದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲ, 274 days ಡಿಲೇ ಇದೆಯಲ್ಲ, ಒಂದೇ ಲಿಸ್ಟ್ ಅಲ್ಲ. ಅವರು ಹಳ್ಳಿ ಶಾಂತಪ್ಪ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲ ಸರ್. 25,000 ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರ, ವೆರಿಫೈ ಮಾಡಿ ಅಂತ ಹೇಳವ್ರೆ. ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ಲ ಅವರು.